Hello, good morning, and welcome to Byju's exam prep. In the last class on Friday, we initiated the discussion on citizenship. What is citizenship? Normally, this chapter is not mentioned in the Constitution. Why? Because if something is mentioned in the Constitution, it stays there for a long time because it's very difficult to amend the Constitution. That is why this matter citizenship is left to the legislature concerned. You decide, basis the law that you pass, who can be the citizen, who cannot be the citizen, because these conditions may change frequently. But since the country was partitioned along the religious lines, we had to be absolutely sure who are the citizens of India. That is why this chapter was mentioned in the Constitution. For example, there are students who are attending this class who may not have enrolled with us. They're attending the class for free. Should we not be in a position to identify who are our students so that we can provide them prelims test series, mains test series, the mentorship support, weekly tests, and at the same time, other subjects as well, not just Indian polity. Similarly, to identify who are the real citizens of India so that we can provide them state support, we can provide them benefits. That is why this matter was mentioned in the Constitution, because there was a massive migration of people from India to what became Pakistan and from Pakistan to India. That is why Constitution says under part 2 of the Constitution that we will have Articles 5 to 11. Articles 5 to 10 basically talk about who is the citizen of India right now. In a sense, those who are staying in India right now and they have been residing in India for the past 5 years. You are the citizen of India. Similarly, what will happen to those who migrate from India to Pakistan? What will happen to those if they want to come back? And if they come back on or before July 1948, they will be provided Indian citizenship. After that, they will not be provided Indian citizenship. Article 11 of the Constitution basically gives power to the Parliament, that Parliament can enact a law, and through this law, it can regulate all matters related to citizenship. And that is how in 1955, the Citizenship Act was passed by the Parliament. And it is this Citizenship Act which talks about who can become the Indian citizen, how can you lose your Indian citizenship? And this law has been amended multiple times, as recent as 2019. Let's discuss this law. And therein, we first talked about acquisition of citizenship. How can you acquire the citizenship of India? So one, we discussed by birth. And this is where lots of changes happened. Changes in the sense, till 1987, a child born on the soil of India is the citizen of India, regardless of what is the nationality of his or her parents, doesn't matter. But then in 1987, the law changed. After 1987, if a child is born on the soil of India, this child can become an Indian citizen if either of the two parents is an Indian. If one of the parent is an Indian. Then in 2003, another condition was added. A child born on the soil of India can become the citizen of India if both parents are Indians, if one of the parent is an Indian, and the other parent is not an illegal migrant at the time of the birth, which means the children born to illegal migrants can never acquire the citizenship of India. And that is why we say, if till 1987 we were following the concept of Yas Soli, law of the soil, whoever is born on the soil of India becomes the citizen of India. After 1987, and more specifically after 2003, we follow the concept of Yas Sanguini, which means through your blood, you should also be related to an Indian. Otherwise, you cannot acquire the citizenship of India. Then the second way in which you can acquire the citizenship of India is by descent. And what do we mean by descent? Child is born not on the soil of India, but outside the territory of India. For example, you clear the civil services examination, you become the IFS officer. And as an IFS officer, you are posted in United States, for example. And there a child is born. Child is born to you. Whether your spouse is Indian or foreigner doesn't matter. The child is born. Can this child become the citizen of India? Yes. Provided you register the birth of this child at an Indian embassy within 1 year of the birth. A child is born, but not within the territory of India, outside the territory of India, to an Indian parent. Whether both parents are Indians or one parent is an Indian, can this child who is born outside the territory of India to an Indian parent become the citizen of India? Yes, provided you register the birth of this child at an Indian embassy, at an Indian Foreign Service office. And if you do that, this child can become an Indian citizen by descent. That means not through birth, but by descent, because your parent is an Indian, even if you were born outside the territory of India. And this is where we come across an interesting thing: dual citizenship. And what is that dual citizenship? I told you that India follows a concept of single citizenship. And what is that single citizenship? One, you can only be the citizen of India. It is not that, like United States of America, you are a citizen of India, you are the citizen of Chicago, you are the citizen of India, you are the citizen of Michigan. That means you can only be the citizen of India, not of any other state. Similarly, you can be the citizen of US and at the same time you can be the citizen of any other country. But that's not the case with India. You are only and only the citizen of India. You cannot be the citizen of more than one country at the same time. Any other country apart from India at the same time. But let's assume for a while that a child is born on the soil of United States of America. What do we follow in United States? Yas soli, which means law of the soil, which means whoever is born on the soil of United States can become the citizen of United States. But here assume a child is born to an Indian parent in United States of America. Can this child become the citizen of India by descent? Yes. But can this child become the citizen of United States as well? Yes, because they follow the concept of law of the soil, yas soli. It is only in this case, only and only in this case, that we allow dual citizenship. That means this child who is born outside the territory of India, this child can become an Indian citizen through descent, but this child can remain the citizen of any other country as well, can follow dual citizenship as well. Because if the child is born in a country where dual citizenship is recognized, where law of the soil is recognized, this child can become the citizen of US, can become the citizen of India as well, dual citizenship. But only till the age of 18. Once this child turns 18, now this individual has to decide, this adult has to decide whether you want to remain the citizen of India or you want to give up your Indian citizenship and you want to remain only and only the citizen of United States. Because you can't have both. Because if you have both, then India will terminate your citizenship because you have to now choose. That means this child, who is now the citizen of India by descent, the child was not born on the soil of United States. The child was not born on the soil of India. The child was born outside the territory of India, but can become the Indian citizen through descent. But if this child is born in a country where dual citizenship is recognized, then this child will have dual citizenship till he or she becomes an adult, completes the age of 18. After completing 18 years, within 6 months, this child will have to decide whether you want to remain the citizen of India or citizen of the other country. It is only in this case where a child is born outside the territory of India that we recognize dual citizenship, but not forever, only till this individual attains the age of 18. Then after attaining the age of 18, within 6 months, you will have to decide. But even if you follow dual citizenship, you have to ensure that you are holding only the passport of India. You cannot be holding the passport of any other country. Even this child who is born outside the territory of India can have dual citizenship, but the passport cannot be of any other country. The passport has to be an Indian. That means one way in which you can acquire the citizenship of India is by birth. If you are born on the soil of India and one of the parent is an Indian, or both the parents are Indians, or one of the parent is not an illegal migrant. Then the other is by descent. Even if you are not born on the soil of India, but you are born outside the territory of India to an Indian parent, the child is an Indian. Which again reiterates that we follow the concept of Yas Sanguini, which means law of the blood, which means wherever you are born, if you are related to India through blood, you can become the citizen of India. Clear? Third way by which you can acquire the citizenship of India is by registration. And there are lots and lots of people who can apply for Indian citizenship through registration. The most recent example is of Akshay Kumar. But we will discuss Akshay Kumar example slightly later, because first we need to understand. To understand Akshay Kumar's case, we need to understand who is the person of Indian origin, who is the overseas citizen of India card holder. What is this concept of non-resident Indian? Once those concepts are clear, we will come back to how Akshay Kumar became the citizen of India again. But here, by registration, who can become the citizen of India? For example, Srimati Sonia Gandhi. Was she born on the soil of India? No, that means she cannot become the Indian citizen by birth. Was she born outside the territory of India in Italy to an Indian parent or to Indian parents? No, that means she cannot become the Indian citizen by descent. But what she did, fell in love with an Indian, married an Indian, came to India, stayed in India, and once you stay in India over a period of time, you can become eligible to become the citizen of India. And the condition for that is, if you have stayed in India for 7 years, you are eligible to become the citizen of India through registration. That means you are not the citizen of India by birth, you are not the citizen of India by descent, you are the citizen of India because you have registered to become the citizen of India. How? What is the eligibility? There are lots and lots of people who come under this category where you can become the citizen of India through registration. We will discuss those cases. But one such case we are discussing now, which is that of if you're married to an Indian. For example, Sonia Gandhi, not the citizen of India by birth, not the citizen of India by descent, but what she did, she married an Indian. Once she married an Indian, she came to India. She came to India, although the marriage was done in India, but she came to India, married an Indian, and stayed in India for 7 years. After the 7-year period is over, and she has also given up her Italian citizenship. You cannot be the citizen of Italy and India at the same time. In fact, you cannot be the citizen of any other country if you are the citizen of India. So you will have to give up your previous citizenship. Sonia Gandhi, after 7 years of staying in India after her marriage, she became eligible to become the citizen of India. She applied for Indian citizenship, got the Indian citizenship, and then she gave up Italian citizenship. That means once you receive the citizenship, before that you should say that once I receive the citizenship, I will give up my previous citizenship. And once you give up your previous citizenship, you become the citizen of India through registration. Can somebody tell me in the comment section, is Sonia Gandhi eligible to become the Prime Minister? Can she become the Prime Minister? Roshan says no. Asmita says no, no, yes, 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 no, no. A lot of people saying no. That's why I asked this question. For the civil services examination, there are a few things that you must do. Delete your Facebook account, delete your Twitter account, delete your Instagram account, and at least if you can't do this, do not follow Subramaniam Swamy on Twitter, or do not follow those with extreme views, which may not necessarily be true. There are lots of good things that Subramaniam Swamy has done, but over a period of time, you're also saying something to cater to the wider audience for publicity. Indian Constitution says, if you are a citizen of India, you can contest elections. It does not say you should be the citizen of India by birth, then you can contest elections. Constitution says, if you are the citizen of India, regardless of through which route, whether through birth, by descent, registration, you are the citizen of India, you can contest elections. And anybody who is a member of parliament can become the Prime Minister as well. So isn't Shrimati Sonia Gandhi the member of Lok Sabha from the Raebareli constituency? Yes, she is. Which means if she is eligible to become the member of the parliament, she is eligible to become the Prime Minister as well. But sir, in 2004, Dr. APJ Abdul Kalam refused to swear in Shrimati Sonia Gandhi. That is why Manmohan Singh became the Prime Minister. This is not true. How do I know this? Not that Mr. APJ Abdul Kalam told me, but he writes in his book. He writes in his autobiography that I had no hesitation in swearing in Shrimati Sonia Gandhi, but they proposed Dr. Manmohan Singh instead. So it is not that APJ Abdul Kalam had refused to swear in the Shrimati Sonia Gandhi as the Prime Minister. It was basically the Congress party which recommended Dr. Manmohan Singh instead. Clear? So whether you are a citizen of India through birth, through descent, through registration, or any other route, you can become the Prime Minister of this country. It's only in United States that the individual who wants to become the President of United States, you should be the citizen of US by birth. It's not that the citizenship you could have acquired later on. Those who have acquired citizenship later, they cannot become the US presidents. You should be the citizen of US by birth in order to become the US president. But be that as it may, one way in which you can acquire Indian citizenship is through birth, the second through descent, third through registration, and there are lots of people who are eligible under registration. I discussed one example, for example, marriage. Clear? Okay. Fourth is by naturalization. Imagine a situation that you are an individual, you cannot become the citizen of India by birth, you cannot become the citizen of India by descent, you cannot become the citizen of India by registration as well. For example, you are not married to an Indian. Clear? One such example. But you still love this country and you want to become the citizen of this country. Is there any other way? Yes, there is. And that route is known as naturalization. For example, Adnan Sami. For example, Mother Teresa. For example, John Draze. If you are a civil services aspirant, you would have or you might have read Dr. John Draze writing in Hindustan Times, the Indian Express, the Hindu newspaper as well. All these are citizens of India through naturalization. But there are some strict conditions that you will have to follow in order to become the citizen of India through naturalization. Condition number one, you should not be from a country where Indians are not allowed to become citizens. For example, if you are from Saudi Arabia and you want to become the citizen of India, can you become the citizen of India by birth? No, because you are not born on the soil of India. Can you become an Indian citizen through descent? No, because one of the parents is not an Indian. Can you become the citizen through registration? No, because, for example, you're not married to an Indian. Is there any other way in which you can become the Indian citizen? Through naturalization. But you should not be from a country where Indians are prevented from becoming citizens. For example, in Saudi Arabia, an Indian cannot become the Saudi citizen. In fact, Saudi Arabia, they have a very strict rules for citizenship. The king gets to decide. Otherwise, they don't award citizenship to others. That means this foreigner who is from Saudi Arabia or from a country such as Pakistan, where Indians are not allowed to become citizens, if you want to come to India and become the citizen of India through naturalization, you will not be allowed. Why? Because in your country, Indians are not allowed to become citizens. Which basically means in order to become the citizen of India through naturalization, you should be from a country where Indians are allowed to become citizens. Number one. Number two, you have to give up your previous citizenship. You cannot hold dual citizenship. Third, you should have an adequate knowledge of any of the languages mentioned in the 8th schedule of the Constitution. We'll discuss 8th schedule, and there are 22 languages which are mentioned in the 8th schedule. Hindi, Bodo, Bengali, Odia, Malayalam, Tamil, Kannada, Telugu, so on and so forth. So many languages. Sindhi, Nepali is also a language in the 8th schedule. If you have an adequate knowledge of any of these languages mentioned in the 8th schedule, you are eligible to become the citizen of India through naturalization. Also, your intention should be to reside in India permanently. Your intention should be to make India your permanent home. And for that also, the condition is 14 years. Condition is 11 years. Condition is 1 year. So what is this 14 years, 11 years, 1 year? Listen to me carefully. Adnan Sami, for example, came to India in around about 2001. You should want to become the citizen of India through naturalization. But there are some conditions that you have to follow. You should not be from a country where Indians are not allowed to become citizens. You should have an adequate knowledge of any of the languages mentioned in the 8th schedule. Your intention should be to reside in India permanently. You have to give up your previous citizenship. And there are other conditions as well. But one such condition is the time period, the amount of time that you have spent in India. And we say this individual who wants to become the Indian citizen through naturalization, he or she should have stayed in India for 14 years. And once you stay in India for 14 years, then you can apply for Indian citizenship through naturalization. Sir, what will happen because of this 14-year stay? Because then we can say that your intention is to reside in India for a permanent basis. It should not be that you come to India and within a day you become the citizen of India through naturalization and your primary intention is to buy agricultural land in India. Your primary intention is to buy property in India. That should not be the primary intention. Intention should be that you want to make India your permanent home. For that, you should have stayed in India for 14 years. So does that mean in all these 14 years, you should have never left this country? No. You can leave this country as well, then you can come back. You can go out of this country for tourism, for medical tourism, for business, for any other purpose. But out of these 14 years that you have stayed in India, for example, you came to India in 2000. Then in 2014, you can apply for naturalization, citizenship by naturalization. Does that mean in these 14 years, you should have never left this country? No, you can leave this country as well. But when we add the number of days you were in India, when we add the number of days you were present in India, that number should add up to 11 years. That means in all these 14 years, when we add the number of days you were in India, that number should add up to 11 years. That's the condition. And 1 year, what is this 1 year? For example, you are applying for Indian citizenship through naturalization in 2014. When you apply today, for example, today it is 9th of October 2023. If you apply for citizenship through naturalization on the 9th of October 2023, in the past 1 year, that means past 1 year from the date you're applying for citizenship, you should have never left this country. That means you should have stayed in India for 1 year continuously before making this application. That is this condition. That means there are some strict conditions that you have to follow. I can become the citizen of India by birth, by descent, by registration. If I'm ineligible under these routes, there is still a way I can become the citizen of India, that is through naturalization. And naturalization in the sense, if you want to become a citizen of India through naturalization, you should have stayed in India for 14 years. After that, you're eligible. But out of these 14 years when you were in India, the number of days you were present in India, not abroad, should add up to 11 years. And if you're applying for citizenship today, then preceding 1 year, you should have never left this country. That means there are some strict conditions that you need to follow. But which ministry is responsible for all these citizenship matters? That ministry is MHA. Ministry of Home Affairs. Government of the day has the power. Citizenship is a matter which is left to union, the central government. States don't have a role. What the central government can do, it can waive off all these conditions. That means you don't have to be present in India for 14 years. That condition is waived off for you. You don't need a working knowledge, adequate knowledge of any of the languages mentioned in the 8th schedule. We don't need it. All these conditions except dual citizenship, because dual citizenship under no circumstance can be accepted. All other conditions can be waived off, provided this individual has performed spectacularly, has had glorious contribution in the field of art, literature, human peace, world progress. If you have made glorious contributions in all these fields, and we want such individuals to be the citizens of India, we can waive off all these conditions, except dual citizenship. Sir, how Adnan Sami became the citizen of India? Because he was previously from Pakistan, and in Pakistan, Indians are not allowed to become citizens. That's one of the questions. Adnan Sami's father was the pilot of Pakistani Air Force and participated in the 1965 war. But Adnan Sami had taken up Canadian citizenship. And now when he came to India in 2001, he was a Canadian citizen. And in Canada, you would know Indians are allowed to become citizens. It's like a mini Punjab in Canada, whatever it is called. The fact is that since in Canada, Indians are allowed to become citizens, Adnan Sami was a Canadian, and as such, he was eligible to apply for Indian citizenship through naturalization. And once you apply, you're given citizenship, you also have to take an oath that I subscribe to the Constitution of India. I owe my allegiance to the state of India. So one more way by which we can acquire the citizenship of India is through naturalization. And the fifth way by which one can acquire the citizenship of India is by incorporation of territory. Territory in the sense, Goa was not part of India initially in 1947. Goa later on became part of India. But when we incorporate Goa into India, when we acquire Goa into India, or we acquired Sikkim, or we acquired some French colonies, some Dutch colonies, all these people who are now part of India, can they become the citizens of India as well? Yes. One thing, if tomorrow we acquire Pakistan, does that mean all Pakistani citizens automatically become the Indian citizens? No. The central government will specify Specify is the word. Who are the citizens of that territory which we have acquired? Who can become the citizens of India? Others cannot. For example, if we acquire Pakistan, we may want that those who participate in Coke Studio should become the citizens of India. But we don't want Imran Khan to become the citizen of India. We don't want Hafiz Saeed to become the citizen of India. We don't want Masood Azhar to become the citizen of India. We don't want these irritating people in ISI and Pakistani army to become the citizens of India. Yes, some of the cricketers, hockey players, squash players, the javelin thrower can become the citizen of India, but not others. Which means when you acquire the citizenship, when you acquire another country, another territory, when you incorporate that into the territory of India, the central government, which is the Ministry of Home Affairs, will specify who are these people who can become the citizens of India. Others cannot. These are the 5 ways by which one can acquire the citizenship of India. 1, by birth, by descent, by registration, by naturalization, by incorporation of a foreign territory. These are the 5 ways. Any questions? Let me know. Is it correct that a child born to Indian parents in another country possess dual citizenship until the age of 18, if such a statement is asked? Yes, this statement is correct, provided you are born in a country where dual citizenship is recognized. Otherwise, no. Sir, if anyone who becomes citizen by naturalization can become the citizen of President of India, in order to become the President of India, you should be a citizen of India. It is not mentioned that you should be the citizen by birth or citizen by descent or citizen by registration, or it is not explicitly mentioned that you should not be the citizen through naturalization. That means any citizen, whether you have acquired citizenship through any route, whether birth, descent, registration, naturalization, incorporation of a territory, you can become the President of India. How will they prove that they have lived in India for 11 years? Travel documents, my dear. You are stamped when you enter India. You are stamped when you go out of India. So all these records are there. What is the difference between CAA and NRC? My dear, we have not discussed it yet. Wait. Sir, what qualities did Adnan Sami had? Is the fastest piano player in the world, a good singer, a good musician, lost a lot of weight as well. That should qualify him. That is not a qualification, by the way. That was just a joke. If the statement says under no condition India recognizes dual citizenship, is this false or true? This is false because there is a condition in which India recognizes dual citizenship. What are the ways? Akshay Kumar case. I told you Akshay Kumar case we will discuss once we have an idea of who is an OCI, who is a PIO, who is an NRI. We'll discuss that case. Once this chapter citizenship is over, I'm sure you will have no doubts in your mind. But somebody is asking me, sir, what are the ways by which one can lose the citizenship? That, my dear, we'll have to discuss now. Patience. Okay. What are the ways by which one can lose the citizenship? One is renunciation. What is a renunciation? It's a voluntary act. Look at the data. Lakhs and lakhs of people in a year, they voluntarily give up their citizenship. For example, you move to Australia, New Zealand, Canada, US, Britain, other European countries, Scandinavian countries, and you want to become the citizen of those countries. But since India does not recognize dual citizenship, what do? You renounce, you give up, you voluntarily give up your citizenship. That means one way in which you can lose your citizenship is if you voluntarily want to cut ties, if you voluntarily want to give up your citizenship. And that voluntarily giving up your citizenship is what we call a renunciation. But listen to me carefully. I am an Indian. My wife is an Indian. But the kids are minors, less than the age of 18. If both of us want to give up our citizenship, what will happen to these minor kids? They will also lose their citizenship. That means the kids, the minor children of parents who have given up their citizenship, these minor kids, they will also lose their citizenship. But sir, what if after watching Swades, Ye Jo Desh Hai Mera, they become so patriotic that they want to come back and they want to open a factory in India, or they want to stay in India or work in the rural areas. Here, once these minors, they turn adults, they cross the age of 18, then they can become the citizen of India again. So through which process? That is why I told you under registration, there are a lot of individuals who can come in. We will discuss those cases one by one once we reach there. All these minors, they can become the citizen of India again through registration. Sir, what are you trying to say? If there are 5 ways in which you can acquire Indian citizenship, there are 3 ways by which you can lose your citizenship as well. One is renunciation. You voluntarily give up your Indian citizenship. Okay, do it. That's how lakhs of people do every year. And we have the data as well. But be that as it may, but if you and your partner, your spouse, you want to give up your citizenship, what will happen to the minor kids that you have? If you have adult kids in the sense, if you have adult children, then they have the right to decide whether they want to give up their citizenship or not. Parents may give up, but the children, they will decide, since we are adults, we want to remain in India, so they will not lose their citizenship. But if you are a couple and you have minor kids, if you want to renounce your citizenship, these minor children, they will also lose their citizenship. But you will say that this is like you are punishing them for no fault of theirs. You're punishing them for the fault of their parents. It's okay. But once these individuals, they turn adults, they cross the age of 18, and if they want to become the citizens of India now, because now they are in their full age and capacity, they are adults, they can decide for themselves. All they have to do, they have to register for Indian citizenship. That means they were the citizens of India previously. But since their parents, they gave up their citizenship, they also lost their citizenship. Now, if they want citizenship again, they will have to register for Indian citizenship. All they have to do, come to India, stay in India for 5 years, and after 5 years, they're eligible to become the Indian citizenship through registration. Clear? Second, by termination. And what is that termination? For example, you acquired the citizenship of Italy without renouncing Indian citizenship, without voluntarily giving up your Indian citizenship. That means you're holding 2 citizenships at the same time. When and if the government comes to know about that you have voluntarily acquired the citizenship of another country without giving up your Indian citizenship, in this case, what the central government will do, the central government will terminate your Indian citizenship. That means through force. One way in which you can lose your citizenship is by renunciation, voluntary act. I want to voluntarily give up my Indian citizenship. The second is through termination. You acquired citizenship of another country without giving up your Indian citizenship. When the central government comes to know about that, your Indian citizenship will be terminated because we do not recognize dual citizenship. Clear? And the third way in which you can lose your citizenship is by deprivation. How deprivation? This deprivation clause or condition applies to those who have acquired citizenship through registration or naturalization. That means if you are a citizen of India by birth, if you are a citizen of India by descent, either you can voluntarily give up your citizenship, which is renunciation, or your citizenship can be terminated if you have acquired citizenship of another country. Otherwise, the central government cannot take away your citizenship. But you can be deprived of your citizenship if you have acquired citizenship through registration and naturalization. Registration or naturalization, but through fraud, through false representation, through concealment of material facts, or if you have been disloyal to the Constitution. For example, to become the citizen of India through registration, you should be married to an Indian. What if just to acquire Indian citizenship, you faked a marriage certificate? Now you can be deprived of your citizenship because through fraud you acquired Indian citizenship. Clear? Or if you have concealed some information, false representation, concealed information, you said I have the adequate knowledge of Hindi, but that was false. You didn't have the adequate knowledge of Hindi. Or you said I have stayed in India for 14 years, but you through forged documents, you forged some documents to prove that you have stayed in India for 14 years. Otherwise, you had not. Which means, be that as it may, if you have acquired citizenship through registration or naturalization, but through fraud, through false representation, through concealment of facts, or if you are disloyal to the Constitution, your citizenship can be deprived. You can be deprived of your citizenship. And once you're deprived of your citizenship, you will never become the citizen of India again. Not just that. All those Indians who have stayed outside India for 7 years continuously, you can also be deprived of your citizenship. That is why in your family or your extended family, if you have people working outside, you will see that every year they come to India. Or every 7 years they have to come to India. Because if you have stayed outside the country for 7 years continuously, you will be deprived of your citizenship. Although this does not apply to students, to Indian diplomats outside, so on and so forth. But if you are outside the territory of India for 7 years continuously, your citizenship can be deprived from you. That's what we call deprivation. Any questions? Sir, a person becomes Indian citizen through marriage. If they divorce, that citizenship continues to that person? See, there are lots of permutations and combinations. Don't get into that because those things will not be asked in the examination. Once you have become the citizen of India, after that, if the divorce has taken place, you are still the citizen of India. Clear? But there can be lots of permutation and combination in the sense, sir, during those 5 years you were married In the 6th year you got divorced, on the 7th year you married a foreigner, 10th year you married an Indian again. Lots of permutations and combinations. Don't get into that. Just understand the concept, be done with this, because a numerical on this topic will not be asked in the exam. Sir, what all documents can be considered as a proof of citizenship? We don't know. We will discuss NRC, for example, later, National Register of Citizens. And then there is a demand, and there is also a proposal that we should conduct a nationwide NRC. There the question is on how can you prove your citizenship? What are the documents which you can say can prove that you are the citizen of India? We don't know. But we will discuss that. Can adopted children become the citizens of India? Adopted children cannot become the citizen of India through descent or through birth, which means they have to register themselves as the citizens of India. By incorporation of territory, please explain. Incorporation of territory means you have acquired another country. For example, Goa we acquired, we incorporated. That means we included Goa into the Indian territory. What will happen to the Goans? What will happen to those who are part of Goa? They will also become the citizens of India. But central government will specify who are these people in Goa who can become the Indian citizens. Yes, even if you are a citizen of India by birth, then deprivation clause does not apply. But if you have acquired the citizenship of India through descent, through naturalization, through registration, but you got the citizenship and then for 7 years you disappeared from the country, your citizenship can be deprived from you. Okay, now let's discuss who is the person of Indian origin, who is an overseas citizen of India. There was a scheme launched by the Ministry of Home Affairs in the year 2002. What was the scheme? This was to provide some benefits. Benefits to whom? Diaspora. Diaspora in the sense, you were Indians, but you migrated to US or any other country, acquired the citizenship of these countries, which means you are no longer the citizen of India, but you were once the citizen of India, but now you are holding important positions in government, in bureaucracy, in business, in arts, in different countries, which means you have an influence. Through your influence, you can even have and result in a friendly relations between India and those countries. Although not a those are what we call diaspora. This is where we come across a term known as soft power. How can we exercise influence over Russia, for example? For example, how can we exercise influence, control over Russia? Through hard power, which means through missiles, through rockets, through our ammunition. That means through your hard power, through your missiles, you can exercise control over Russia. But there is another way in which you can exercise control over Russia, that is through soft power. If you can somehow control the public opinion in Russia, if Vladimir Putin would understand that people in Russia, they support India. Vladimir Putin in his dealings with India, in his policies vis-a-vis India, will be very sympathetic to India, will be very good to India. Why? Because otherwise, if he's not good to India, he will lose the popular support in Russia. Because the people there support India. And there was one individual who was responsible for good relations or starting good relations or ensuring good relations between India and Soviet Union, India and Russia. And that was Shri Raj Kapoor. Raj Kapoor, he would travel to Russia, and in Russia, he would screen and film his movies. because of which the relationship between India and Russia became very strong, became very solid. So diaspora, in the sense, those who were previously citizens of India but now citizens of other countries, there they are holding important positions, and through those positions they can influence those governments to have good relations with India. Diaspora. Or not only them, their children, their grandchildren, their great grandchildren, they once had Indian ancestry. Their forefathers were Indians. Definitely they will be sympathetic to India. And ultimately, what will happen? They will use their influence to have good relations with India. So in 2002, the Ministry of Home Affairs decided that let's implement a scheme known as the Person of Indian Origin, so that to this diaspora we can provide some benefits. Who is eligible to become the person of Indian origin? That means one card will be given to them. Who are eligible to become the persons of Indian origin? If at any point in time you held an Indian passport. And who can hold an Indian passport? An Indian. That means at any point in time you were an Indian. Now you are no longer an Indian, but once you were an Indian, and if you were an Indian, you can apply for the scheme and get PIO card. But what is the benefit from this PIO card? Normally, when you want to visit India or you want to visit any country, you have to apply for visa. For example, a Bangladeshi coming to India will have to apply for visa. And then you have to report, once you come to India, you have to report to the police as well. A department in police known as FRRO, Foreign Registrations, Foreigners Registration Office. But the benefit given to this PIO card holder was, I am a PIO card holder in the sense, I once held an Indian passport. For example, I am Salman Rushdie. My parents were from Kashmir, but I was born in Mumbai, which means I'm an Indian. But I migrated to other countries, traveled different parts of the world, and finally settled in London, finally settled in United Kingdom, and now I am a British citizen. But I once held Indian passport. I suddenly in 2002 got this information that I am eligible for this card known as PIO card. If I apply for this PIO card, because I am eligible, because I once held Indian passport, I can come to India without any visa for 15 years. That means if this card is issued in 2000, till 2015, I can come to India without any visa. And if I'm going to stay in India for less than 6 months, I don't have to report to the police. I may come here for a conference. I may come here for some business meeting. Every time I should not report to FRRO. If my stay in India is for less than 6 months, I don't have to report to the police. But if my stay is for more than 6 months, then I have to report to the police. These are the benefits that I will get. Obviously, when I see these benefits, I will apply for this PIO card. This was one way of engaging with our diaspora, so that you can come to India without visa for 15 years, which basically means you can quickly come to India. And this diaspora, they play another very important role in the form of remittances. Remittances in the sense, I am somebody who was an Indian citizen, but I'm no longer an Indian citizen. I am a citizen of United States. But I have my extended family in India. Maybe my grandfather, maybe my grandmother. And there have also been instances where your second, third, fourth, fifth wife is in India. Clear? So you send money to your family in the form of dollars. Anything which brings dollars to the Indian economy is beneficial to us. And remittance is one of the big way in which money is sent to India from the foreign countries. From Gulf, for example, from US, for example, from Japan, for example. Another condition was, if he or either his parents or grandparents or great-grandparents was born in and was permanently resident in India. Let's say, for example, an individual, the current Vice President of the United States of America, Kamala Harris, she was never holding an Indian passport. But her father, if not the father, grandfather, if not the grandfather, great grandfather, was born in India and was once a resident of India, which means Kamala Harris is also eligible to get this PIO card, which means she can come to India without visa for 15 years, for example. That means one condition was if you were once holding an Indian passport. If not you, then your parent, your grandfather, great grandfather was born in India, was a resident in India. You can also be eligible to get this PIO card. But those, if you are right now from Afghanistan, Bangladesh, Bhutan, China, Nepal, Pakistan, Sri Lanka, you are ineligible. Which means right now, you can be the citizen of any other country except these countries. And you can come to India without visa for 15 years. You don't have to report to the police. All these are the benefits that we are giving to this person of Indian origin. That means you are not Indian, but you are a person of Indian origin. If you once held an Indian passport, or if your parents once held Indian passport, or if your parents, great grandparents, they were once born in India and were the resident of India. But if you are from these countries, you are ineligible. You have to apply for visa. You have to report to the police because we don't trust these countries, according to the government, not me. But then few years later, in 2005, Indian Citizenship Act was amended. Another scheme was launched, and that was known as Overseas Citizen of India. Who is an overseas citizen of India? A foreign national, not an Indian, a foreign national. That means foreigner in United States, foreigner in any other country. But if this foreigner was eligible to become the citizen of India on 26th of January 1950, when the Indian Constitution was enacted. Who was eligible to become the citizen at the time when the Constitution was enacted? If you were present in India, and you had stayed in India for 5 years continuously, you are eligible to become the citizen of India. Such an individual left to United States, became the citizen of United States, but on 26 January 1950, you were eligible. Although you did not apply for it, you did not become the citizen of India, but you were eligible. Now, if you want, we will give you a card, Overseas Citizen of India card. If not you, then you were a citizen of India on 26 January 1950 or any time after that. You were once the citizen of India. If not you, then your sons, daughters, your great grandsons and daughters, you were eligible to become the citizens. We will give you a card known as Overseas Citizen of India. And through this card, what you can do, you can come to India without a visa for life. For life, once this card is issued, you can come to India without visa. You don't have to ever apply for visa. And whether your stay in India is going to be for 6 months, less than 6 months, or more than 6 months, doesn't matter. You do not need to report to police. For any length of stay. Doesn't matter. These were the two different schemes launched. 2002, PIO, Person of Indian Origin. 2005, Overseas Citizen of India. If you were eligible to become the citizen on 26 January 1950, you are eligible to get this OCI card. If you were the citizen of India after 26 January 1950 or any time after that, you are eligible to get the Overseas Citizen of India card. But over a period of time, people realized that we should basically merge the two schemes. Because more or less anybody should become eligible to get this OCI card. In fact, a person of Indian origin, he should get more benefits than overseas citizen of India. Why? Because the link to this PIO to India is very recent as compared to OCI. How? If I once held Indian passport, I am a person of Indian origin. That means my connection to India is recent. Till some time in the past, I had the Indian passport. But who is an overseas citizen of India? Somebody who was eligible to become the citizen on 26 January 1950. I may not have acquired Indian citizenship, yet I am eligible for OCI card. Then it was thought that we should provide similar benefits to PIO card holders as well. And Mr. Modi, when he became the Prime Minister in 2015, he visited United States, addressed a massive crowd of overseas Indians or former Indians or diaspora at the Madison Square. And therein he said, Mitro, I have a news for you. And what is that news? We are going to merge the two schemes. PIO card, this scheme will be scrapped. But don't worry, if you have PIO card, you can convert that card into OCI because OCI card has more benefits. And now the scheme will be known as Overseas Citizen of India Card Holder. Previously, it was known as Overseas Citizen of India. It was also confusing. Why confusing? Sir, you said we do not recognize dual citizenship. Yes. That means you can only be the citizen of India and not the citizen of any other country. Yes. Then why are you saying Overseas Citizen of India? In fact, we had a Ministry of Overseas Indians previously. So this is confusing. Either you say we follow single citizenship or don't mention this term overseas citizen. That means there are some citizens who are local citizens and some citizens who are overseas citizens. That means foreign citizens. Foreign citizen, oxymoron. They're not compatible with each other. If you can be foreigner, you cannot be an Indian. If you are an Indian, you cannot become the foreigner. Mr. Modi said, Mitro, these two schemes are merged. We no longer will follow PIO card because their benefits are less. If you are holding the PIO card, convert it into OCI card. And to avoid the confusion, we will not call it Overseas Citizen of India. We will call it Overseas Citizen of India Card Holder Scheme. And if you have an OCI card, you can come to India without visa for life. If your length of stay in India is for 6 months or less than 6 months or more than 6 months, doesn't matter. You don't have to report to the police because you're an integral part of our development. That's an Overseas Citizen of India card holder. Mr. Akshay Kumar, he was once an Indian, once held Indian passport. Then 2011 became the citizen of Canada. Why? Multiple reasons. We don't have to get into that. He said, my films were flopping. I thought I should choose an alternate career. And for that, some friends recommended that you should come to Canada. I applied for Canadian citizenship. In fact, I even campaigned for one of the prime ministerial candidates in Canada. But be that as it may, I got the Canadian citizenship. That means even if you have a Canadian citizenship, which means you're a foreigner now, but you once held Indian passport, which means you are a person of Indian origin. And once you are a person of Indian origin, which means you can come to India without visa for 15 years. That was the benefit. But if you're holding a PIO card, can you become the citizen of India after that again? If you're holding an Overseas Citizen of India card, can you become the citizen of India again? Yes. If I'm holding a PIO card, I can come to India, stay in India for 7 years. After that, I become eligible to become the Indian citizen. Through what route? Through registration. That means now I have to register to become the citizen of India again. All I have to do, stay in India for 7 years and register for the citizenship of India. But if I'm holding an OCI card, I can become the citizen of India through registration, but I have to stay in India for only 5 years. 7 years for PIO, 5 years for OCI. Now, when both these schemes are merged, that means now when you are holding an overseas citizen of India card, you can come to India, stay in India for 5 years, and after that you become eligible to become the citizen of India through registration. Mr. Akshay Kumar, whose PIO card was converted to the OCI card, stayed in India for 5 years, became eligible to become the citizen of India. That means he registered for the citizenship of India. He got the citizenship of India. So Akshay Kumar is now the citizen of India through registration. Any questions as of now? Any questions? Then we will look at who is an NRI. No, sir, all clear. Countries, Pakistan and Bangladeshis, they are not eligible for OCI card. Because by that logic, since Pakistan and Bangladesh was part of United India, right? Listen to me carefully. It was a united country. Pakistan was born in 1947. Clear? Who was eligible to become the citizen of India on 26 January 1950? All those who were present on the soil of India and those who had remained on the soil of India for 5 years. By that logic, every Pakistani is eligible for Indian citizenship. Every Bangladeshi is eligible for Indian citizenship because it was a united country. Now for OCI, if the condition was you should have been eligible to become the citizen of India on 26 January 1950, that means every Pakistani, every Bangladeshi becomes eligible for OCI card. That means they can come to India without visa for life. Terrorists can come to India without visa. That would be a win-win situation for them. That is why this condition. Does Rishi Sunak come under Indian diaspora? Pakistani say he comes under Pakistani diaspora because his grandparents were part of what is today Pakistan. Whatever it is, we can also call him part of diaspora if that works. Why there is always a fear of terror from Pakistan? Because Pakistan has the policy of exporting terror to India. Sir, Rahat Fateh Ali Khan's citizenship terminated. Rahat Fateh Ali Khan is not an Indian. Dikshit, what is your question, please? Them, then their parents may have been born on that date. If not them, then their grandparents would have been born at that date. That's how you become eligible. Or not. Without non-resident Indian. That means you are an Indian, but non-resident. What does that mean? This is defined under the Income Tax Act 1961. What does that mean? Let's say, for example, you are an Indian, but you are traveling abroad, or your business is abroad. Let's say your business is in United States and you pay taxes in United States. Clear? But you're also an Indian. On the same business, should you be paying taxes in India as well? No, because then it would be double taxation. That means you are an Indian. Indians have to pay income tax, but your business is in United States or your business is in any other country. There you are paying tax. But since you are an Indian, you have to pay income tax in India as well. That would be double taxation. To avoid this, Income Tax Act talks about resident and non-resident Indians. If you are a resident Indian, you have to pay tax in India. If you are a non-resident Indian, that means you are an Indian, but you're residing somewhere else, you have to pay tax there. So only and strictly and purely for the taxation purposes, we define who is an NRI, who is a non-resident Indian, and who is a resident Indian. For that, what is the condition? 182 days in a financial year. Our financial year starts on 1st of April till 31st of March. If in this financial year period, if in this 1 year, you have stayed in India for less than 182 days, you are a non-resident Indian. If you have stayed in India for more than 182 days, you are a resident Indian. And if you are a resident Indian, you have to pay tax in India. If you are a non-resident Indian, you don't have to pay tax in India. As simple as that. This is an NRI. Can these NRIs vote? Can they contest elections? Anybody, can you tell me? Can NRIs vote and contest elections? No, yes, yes, no, yes, yes, no, yes, 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 no, 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 yes. Non-resident Indian. Can an Indian vote? Yes. Can an Indian contest elections? Yes. NRIs can also vote, can also contest elections. But they cannot do that remotely. That means they are residing in US and from there they can vote, from there they can contest. No, they have to come to India to cast their vote. They have to come to India to contest elections. For example, somebody was asking me, sir, what about Kingfisher founder, owner of Kingfisher, Dr. Vijay Mallya? Although he's not a doctor by educational qualification, is not a surgeon or an MBBS holder or has done his PhD. It was an honorary doctorate. A university gave him an honorary doctorate, and then he called himself Dr. Vijay Mallya. But be that as it may, although I have sympathies with him, sympathies in the sense that I don't think he's a thief. I don't think he's a criminal. It was just a case of business going bad. His airline was one of the best airlines India ever produced. Even Vistara cannot match to Kingfisher Airlines. But be that as it may, according to various reports, he owes State Bank of India and other banks 9,000 crores. According to the same reports, he is willing to give these 9,000 crores back to the banks. But the banks are also asking for interest. He says that since my business has gone bust, I cannot pay the interest. At least the principal amount of 9,000 crore I can give you back. But any government, if it allows Dr. Mallya to pay 9,000 crore, it will not be politically good, because then people will get a sense that this government has supported Dr. Mallya, and the public perception is against him, unfortunately. His is only a case of business going bad. Otherwise, Air India, which till recently was under the government of India, taxpayers lakhs and lakhs of crores were spent on Air India. But since the taxpayers' money was used to subsidize Air India continued to fly. And only 9,000 crore liability of Kingfisher Airlines, it has gone bust, and now Mr. Malia is a fugitive. But be that as it may, that's a separate case altogether. Dr. Malia is a non-resident Indian. Despite being a non-resident Indian, he was also a member of Rajya Sabha from Karnataka. How is that possible? Because you are a non-resident Indian only for tax purposes. For any other purpose, you are an Indian. If your name is there in the voter list, you can vote. If your name is there in the voter list, you can contest elections. So who is an NRI? A non-resident Indian. And this residency or non-residency is defined so that you don't have to pay tax at two times or at two places. You pay tax where your business interests are. But in 2020, the finance ministry came up with a change in rules. And what is that change in rules? Finance ministry said that Indians are very clever. Said, yes, we know that. And there are Indians who plan their travel and stay in India in such a manner that they stay in India for less than 182 days. Although their business is in India, although they generate money from India, they generate profit from India, but they plan their travel in such a manner that they remain in India for less than 182 days, which means they are non-resident Indians. And since their primary business is in India, not in any other country, they don't pay taxes anywhere. So if my business is in United States, but I'm an Indian, but I stay in United States, I don't reside in India, I am a non-resident Indian, but I pay tax in United States, I don't pay tax in India. But there are some clever Indians, what they do, their primary business is in India, they raise money from India, but they plan their travel in such a manner that they stay outside of India for more than 182 days. Which means now they don't have to pay tax in India because they are non-resident Indians. They don't have to pay tax in any other country because their business is in India. Finance Ministry said all those people whose income, or should we say taxable income, an income on which tax can be imposed, is more than 15 lakhs from India. All those Indians whose taxable income, who raise money in India, who generate money in India, more than 15 lakhs. If they are not paying tax in any other country, they have to pay tax in India. And for them, this 182 days will be reduced to 120 days. That means all those Indians who are raising money, generating money in excess of 15 lakhs in India, if they stay in India for less than 120 days, they are non-resident Indians. If they stay in India for more than 120 days, they are resident Indians. And as resident Indians, they have to pay tax in India. And if they are generating profits from India and they are not paying tax in any other country, they will have to pay tax in India, regardless of their length of stay, whether they have stayed in India for 180 days or 120 days. Non-resident Indians. Let's club the confusion together. Who is a person of Indian origin? It was a scheme under the Ministry of Home Affairs, under which, for example, if you once held Indian passport, you can get this PIO card. And through this PIO card, you can come to India without visa for 15 years. If your length of stay in India is for less than 6 months, you don't have to report to the police. If your length of stay is more than 6 months, you have to report to the police. And you can also become the Indian citizen through registration if you stay in India for 7 years. 3 years later, another scheme, OCI, Overseas Citizen of India, a scheme under the Citizenship Act of 1955. If you are eligible to become the citizen of India on 26 January 1950, or your father was eligible, or your grandfather was eligible, or great grandfather was eligible, you can become eligible for OCI card. And with OCI card, you can come to India without visa for life. With OCI card, whether your length of stay is for more than 6 months or less than 6 months, doesn't matter. You don't have to report to the police. And you can still become the citizen of India through registration if you stay in India for 5 years. 2015, both these schemes were merged. We no longer have PIO card. Now we have Overseas Citizen of India card holder scheme. And all those with PIO card, they were asked to convert their PIO card into the OCI card. Now we have only this scheme known as Overseas Citizen of India card holder. But who is an NRI? Non-resident yet Indian. You can vote, you can contest elections. This is only for taxation purpose. If you are a resident Indian, you have to pay tax in India. If you are a non-resident Indian, you have to pay tax outside India. But how do we define whether you are a resident Indian or a non-resident Indian? By the number of days you have stayed in India, by the number of days you have resided in India. And for that, we have a law known as Income Tax Act 1961. If you have stayed in India for less than 182 days, you are a non-resident Indian. And why would you stay in India for less than 182 days? Because your business is outside, because you're working outside, which means you have to pay tax there, not here. Otherwise, it will be double taxation. We want to avoid it. If you're staying in India for more than 182 days, you are a resident Indian, which means whatever money you are generating from India, you have to pay tax in India. But then the situation arose where the government realized that there are clever Indians who manipulate their travel in such a manner that although their business is in India, but they plan their travel in such a manner that they reside outside India for more than 182 days, which means they don't have to pay tax in India because they are non-resident Indians. They don't have to pay tax in any other country because their business is in India. So they basically pay taxes nowhere. Now they will have to pay taxes in India if you stay in India for more than 120 days. And if you are not paying taxes anywhere, you have to pay tax in India. If you are generating money in India more than 15 lakhs, if your taxable income from India is more than 15 lakhs, such an individual is a non-resident Indian. Any questions? Let me know. Have a domicile certificate. You're a domicile of Karnataka. You're a domicile of Tamil Nadu. You are a domicile of Maharashtra. This term domicile is not defined in the constitution, but it primarily means a permanent home, a person where an individual resides, and your intention is to remain there for an indefinite period. And we say domicile is not the same as residence. What does that mean? Two things: domicile of origin and domicile of choice. For example, if you are from Maharashtra and if you have a domicile of Maharashtra, there are jobs reserved for you in government. There are seats reserved for you in educational institutions. Similarly, if you are a domicile of Karnataka, there are jobs reserved for you in government. There are seats reserved for you in government engineering and medical colleges. So who is a domicile? And how do you become the domicile of any state? Because you can be the citizen of India and citizen of India alone. It's not that you are the citizen of India and citizen of Karnataka, citizen of India and citizen of Maharashtra, citizen of India and citizen of Tamil Nadu, citizen of India and citizen of UP. You are a citizen of India, you may be a domicile of Madhya Pradesh. You may be a domicile of Goa. You may be domicile of Delhi. And what is that domicile? Domicile is of two types: domicile of choice or domicile of origin. What is domicile of origin? For example, I was born in Delhi. I I did my schooling from Delhi, college from Delhi, and now I'm working in Delhi as well. For example, Delhi becomes my place of birth because I was born in Delhi, for example. Plus, Delhi becomes my residence as well because I'm residing in Delhi. Plus, it's my intention to reside in Delhi permanently as well. Because I'm working in Delhi, I have my house in Delhi, I do everything in Delhi. Delhi now becomes my place to reside permanently as well. Delhi becomes my domicile. But this domicile is that of an origin because originally I am from Delhi. I was born in Delhi. I stayed in Delhi, did my schooling, college, job in Delhi. That means my intention is to reside there permanently. Delhi becomes my domicile, and domicile is of origin. But what if I shift from Delhi, although I was born in Delhi, that means Delhi becomes my place of birth or my origin. I was born in Delhi, but then I migrated to Karnataka. And I took up a job in Karnataka. I resided in Karnataka for many years. Let's say I have resided and I am residing in Karnataka for 15 years. What does that say? That means it's my intention to reside in Karnataka for a permanent time, for an indefinite period. Although I was born in Delhi, but Karnataka becomes my domicile because this is the domicile of my choice. That's the term that we use for this, animus menendi. That means my thought process has changed. I've shifted from Delhi to Karnataka and I made Karnataka my permanent home. Karnataka becomes my domicile. And for such individuals, no matter where you are born, no matter what your origin is, but since you have your intention to reside in Karnataka for an indefinite period, we will provide benefits for you. We will give you reservation in jobs. We will give you reservation in educational institutions. Such a term is known as domicile. The most recent example, for example, Jammu and Kashmir. Prior to 2019, only those who were born in J&K, who had the state subject of J&K, in a sense, who had some document from J&K, only they could have bought land, property in Jammu and Kashmir. After 2019, the government said only the domiciles can buy property in Jammu and Kashmir. Only the domiciles can buy land in Jammu and Kashmir. And who are these domiciles? If you are from any other state, but you have migrated to J&K, and if you have stayed in J&K for 15 years, you become the domicile of J&K. That means your intention is to make Jammu and Kashmir your permanent home. Now you can apply for land and property in J&K. Long story short, what is domicile? Domicile is basically residence plus permanent intention. You are born in Karnataka, but you are working in Delhi. But you have spent schooling in Karnataka, you have a house in Karnataka as well. Your domicile in Karnataka. But you may be working in Delhi. That doesn't mean Delhi is your domicile. Your domicile is still Karnataka. But if you stay in Delhi for 15 years, domicile rules also vary from state to state. For example, if you stay in Delhi for 15 years, that means you have made your intention of residing in Delhi for an indefinite period. You become now the domicile of Delhi. But you cannot hold two domicile certificates. If you're possessing two domicile certificates, domicile certificate of Karnataka as well as Maharashtra, it's a crime. There was one individual, one student, who just because he wanted an admission in a good college, good MBBS college in Maharashtra as well as Rajasthan. He got the domicile of both the states. Somebody got to know about that, complained, and ultimately he lost his domicile certificate, and for 15 years he cannot apply for any exam. So that's the crime. But what is domicile? Domicile is of two things. Can be of two types. Domicile of origin. You were born in Karnataka. You stayed in Karnataka. You did your schooling in Karnataka. Now you have a job in Karnataka as well, which means you're staying in Karnataka for 15 years, which means Karnataka becomes your domicile. It's your place of birth as well. It's your domicile as well. But your domicile is same as your origin. Your origin is Karnataka. You also decide to make Karnataka your permanent home. Karnataka becomes your place of birth. It becomes your origin. It becomes your domicile. But after some time, you decide to shift to Tamil Nadu. And you have stayed in Tamil Nadu for 5 years, 6 years, 10 years, now 15 years. Which means, what are you trying to say? You're saying that I have my intention of residing in Tamil Nadu for an indefinite period. Now you become the domicile of Tamil Nadu. And as the domicile of Tamil Nadu, you may have reservation in jobs. You may have reservation in educational institutions. That is domicile. The district authorities may give you the domicile certificate. So you have to apply for a domicile certificate in your district office. If I was born in state X but completed my schooling and college in state Y, am I still eligible for domicile status in state X? Yes, you are a domicile of X unless and until you want to give it up and you want to get this domicile of state Y. In Himachal Pradesh, just like in Manipur, in Meghalaya, in Nagaland. Karnataka region, the 6 backward districts, Bidar, Raichur, Bellary, Gulbarga, so on and so forth. So, domicile of Jharkhand. Break, and after the break, we will meet. We will discuss the Citizenship Amendment Act 2019. Let's meet at 7:40. Citizenship Amendment Act 2019. When we say Citizenship Amendment Act, it basically means the Citizenship Act of 1955 was amended in 2019. What was the need to amend? What are the provisions of this law? What are the arguments in favor of this law? What are the arguments against this law? Why this matter is before the Supreme Court? What Supreme Court will rule on this matter? And how is CAA linked to NRC or National Population Register? What is a census? What is socio-economic caste census? What is the caste census or caste survey which has been carried out by the government in Bihar and whose findings have been published? What is the demand for a caste census in India? Is that good, bad, or ugly? All that is something that we will discuss now for the next 1.5 hours. If we are not able to complete it today, we will complete it tomorrow. And tomorrow we will initiate a discussion, a fascinating discussion on fundamental rights. Now, there are 3 countries Don't ask any questions as of now. I'm sure there will be lots of questions on your mind regarding this topic. But first, allow me to discuss this topic in its entirety, and then we will open the floor for questions. And after that, if you have any questions, please shoot. But as of now, just listen to me patiently, calmly, write whatever I'm discussing and I'm writing on the screen. That is important for your exam. But listen to me carefully. There are three countries: Pakistan, Afghanistan, and Bangladesh. These are our neighboring countries in our neighborhood. And these are the countries where Islam is the state religion. And any country where one particular religion is a state religion, we call such countries theocratic countries. Theology bases a religion, where religion is a predominant part of their lives, where the state has proclaimed that one of the religion is the state religion, which gets more dignity, more protection. And in our neighborhood, we have three countries: Pakistan, Afghanistan, and Bangladesh. These are Islamic countries where Islam is the state religion. We call them theocratic countries. Any country where one religion is a state religion becomes a theocratic country. For example, Israel is a theocratic country. And in these countries, there are religious minorities. If Islam is the state religion, which means majority of the people in these countries are Muslims, and then we have religious minorities, for example, Hindus, Christians, Sikhs, Buddhists, Jains, Parsis. These are the 6 religious minorities in these 3 countries where Islam is the state religion, and these religious minorities have been persecuted. Discriminated against, tortured, some of them killed, some of them raped, and some of them forcefully converted to Islam. And now when there are these religious minorities which are not feeling safe in Pakistan, Afghanistan, Bangladesh, what would they do? They would basically migrate and they would enter India. But to enter India, they need to enter India legally. In a sense, they should hold the passport of these 3 countries. They should have the visa to enter India. But when you are fleeing your country, when you want to quickly leave your country, Pakistan, Afghanistan, Bangladesh, because you want to save your life, you want to save your dignity, and without any passport, without any visa, you try to come to India, that means in India, who are you? You are an illegal migrant. And we have discussed that illegal migrants cannot become the citizens of India. The children of these illegal migrants cannot become the citizens of India, because after 2003, we have a condition that if you are born on the soil of India, one of the parent has to be an Indian, the other cannot be the illegal migrant at the time of your birth. And if you are a children of the illegal migrants, you cannot become the citizens of India. But who are these 6 religious minorities from these 3 Islamic countries? 6 religious minorities belonging to Hindus, Christians, Sikhs, Buddhists, Jains, Parsis. They have come to India, but without visa, without any travel document, maybe without passport as well. And in India, they are illegal migrants, which means they're not eligible for citizenship, which means their children are not eligible for citizenship, which means they will not be eligible for the state support. This was part of the manifesto of the BJP. The Bharatiya Janata Party in its manifesto said that all these illegal migrants from these 3 Islamic countries belonging to these 6 religious minorities, we will give them citizenship. And to provide citizenship to these people, that is how Citizenship Amendment Act was passed in 2019. But before that, 2 important notifications were issued by the Government of India. What are these important notifications? Notification said that all these people should be exempt from Foreigners Act and Passport Entry into India Act 1920, which means every foreigner who comes to India should hold the passport of their country. Otherwise, they cannot come to India. All these foreigners who come to India, they should have that valid travel document. They should have the Indian visa to come to India. Otherwise, they will not be allowed entry. And normally, if you are violating these laws, action can be taken against you. What is the action? Basically, you will be arrested and then you will be deported. That means all those individuals, all those foreigners who come to India without passport, without travel document, without visa, action will be taken against those violators because you are violating these laws, which means you will be arrested. And once you are arrested, proceedings will start against you. Once proceedings will start against you, we will then have to identify, the government of India will have to identify from which country have you come to India, and we will deport you back to that country. In 2016, what the government said all those who have come to India from Pakistan, Afghanistan, Bangladesh, if they belong to these 6 religious minorities, Hindus, Christians, Sikhs, Buddhists, Jains and Parsis, they will be exempted from the Passport Act, they will be exempted from the Foreigners Act. Which basically means they don't have to come to India with a passport, they don't have to come to India with a valid travel document. And the government of India said in its Citizenship Amendment Act that these shall not be deemed as illegal migrants. If they have come to India on or before December 31, 2014. And even if for such individuals, if proceedings were initiated against them, all those proceedings will be closed. And the moment they have entered India, from their date of entry to India, they will be provided citizenship. To make it even clear to you, the BJP contested elections on a promise, a manifesto, because every political party releases a manifesto, a set of promises that they make to the people. If you vote for us, we will fulfill these promises. For example, people in Karnataka voted for the Congress in elections, in the Legislative Assembly elections this year. Why? Because they promised that we will give you free bus rides for all the women, we will give you scholarship, we will give you pension, we will spend 62,000 crore for all the promises that we have made, so on and so forth. So you basically want people to vote for the set of promises that you are making them, and we will fulfill these promises. One such promise made by the BJP to the people of India was that if there are people who belong to 6 religious minorities from these 3 Islamic countries, if they have come to India on or before December 31, 2014, they will not be deemed as illegal migrants. That means although they are illegal migrants, but they will not be deemed as illegal migrants. If they are not deemed as illegal migrants, that means they are eligible for citizenship. That means they're eligible for citizenship through naturalization. And normally the condition is you should have stayed in India for 11 years. Because to fulfill the condition for naturalization, you should have stayed in India for 14 years. Out of those 14 years, you should have stayed in India for 11 years. That means for 11 years, you should not have left this country. The condition for naturalization for these set of migrants was reduced from 11 years to 5 years. Which basically means if you are from Pakistan, Afghanistan, Bangladesh, but if you are Hindus, Christians, Sikhs, Buddhists, Jains, Parsis, and if you have entered India on or before December 31, 2014, you should have stayed in India for 5 years instead of 11 years. If you have stayed in India for 5 years, you are eligible for citizenship through naturalization. And no matter when you have entered India, whether December 31, 2014, or December 1st, 2010, or January 1, 1965, or January 6, 1971, whatever date you have entered India, you will be declared citizen of India from that date. That means the date you have entered India, the date of your entry to India, that date will be determined. That means on that date you have become the citizen of India. And it may be possible that some of these illegal migrants, they may have been arrested. Proceedings have been started against them, and some of them may be deported back to their country. That means some of them, according to our existing laws, will be arrested, will be deported back to Pakistan, Afghanistan, Bangladesh. But in these three countries, their life would be in danger. So even if proceedings were started against them, all those proceedings will be closed because now they are eligible for citizenship through naturalization. That was Citizenship Amendment Act 2019. According to this act, there are some exemptions. Exemptions such as there are some states where we have tribal areas. Those states are under Schedule 6 of the Constitution. There are some states which have Schedule 5 areas. And there are some states which have Schedule 6 areas. We will discuss both these in our chapter schedules, but very briefly here. Tribes. We consider tribes as the original inhabitants of India. Although there is a theory known as the Aryan invasion theory, although this theory has been discredited now, this theory is no longer trusted now. But whether it is trusted or not, according to this theory, Aryans came from outside. They came to India from Central Asia, from other parts, they came to India. And in India, there were the original inhabitants, those who were already present in India. Those are what we call tribes. But when Aryans came from outside, these tribals, they were pushed. They were pushed towards the forests. So these Aryans inhabited the mainland India. These original inhabitants, who were the inhabitants of this country, they were pushed to the forests. And when they were pushed to the forests, they maintained their own individuality, they maintained their own identity, they maintained their district language, script, culture. And we have to preserve their culture. That is why any tribal area gets protection. And there are 4 states which come under Schedule 6 of the Constitution, where their language, their script, their culture, their religion is protected. And those are the states of Assam, Meghalaya, Mizoram, and Tripura. But it's not that entire Assam is a tribal area. Entire Tripura is a tribal area. Entire Mizoram and Meghalaya is a tribal area. There are 3 districts in Assam which are a tribal area. Similarly, 3 districts in Meghalaya. Similarly, 3 districts in Mizoram. Similarly, 1 district in Tripura. There are 10 districts in these 4 states, Assam, Meghalaya, Mizoram, and Tripura, which are a tribal area. So these illegal migrants, who are now not illegal migrants, because we say you are not an illegal migrant. When you are not an illegal migrant, that means you will be given citizenship. And when you are given citizenship, you can move freely throughout the territory of India. You can reside and settle anywhere within the territory of India. But the exemption of CAA says these citizens, who are now citizens, these people from Pakistan, Afghanistan, Bangladesh, belonging to 6 religious minorities, they will be made to reside anywhere within the territory of India except the tribal districts of Assam, Meghalaya, Mizoram, and Tripura. That means they will be made to settle in any other part of this country, any other territory of this country except the tribal areas which come under Schedule 6 of the Constitution belonging to Assam, Meghalaya, Mizoram and Tripura. But sir, then why are the people in Assam protesting that we will not implement Citizenship Amendment Act? Why did they protest? Why were killings happening in Assam when this law was passed? Because the entire Assam is not a tribal area. That means these migrants who are now the citizens, who will be the citizens, they will be made to settle in other parts of Assam except the 3 tribal areas, except the 3 tribal districts. So they will be made to settle in non-tribal areas of Assam, Meghalaya, Mizoram and Tripura, but they will not be made to reside in these tribal areas. Similarly, they will not be made to reside and settle in those areas which come under Inner Line Permit. Inner Line Permit was used by the British by way of a law known as Bengal Eastern Frontier Regulation Act 1873. What was the need? The need was that there were tea plantation areas in northeast. For example, Assam. There were some areas in the northeast for which workers, laborers were sent from other parts of the country. For example, Santhals from Odisha, Jharkhand, and other states. They were sent to work in these plantation gardens. But without the permit, without the permission, you cannot enter these areas. Such a permit exists even today. For example, Arunachal Pradesh, you cannot enter Arunachal Pradesh without the permission from the district authorities, from the state authorities. That's what we call inner line permit. That means although you are an Indian, but if you want to go to Arunachal Pradesh, you need a permit to enter Arunachal Pradesh. This permit, you have to say, what is the purpose of your entry to Arunachal Pradesh? How many days can you spend in Arunachal Pradesh? Such a system does not exist anywhere in India. That means you can come from Bihar to Jharkhand, from Jharkhand to Karnataka, from Karnataka to Tamil Nadu, Tamil Nadu to Maharashtra, Maharashtra to Goa. You don't require permission. But there are some areas which come under inner line permit. For example, Arunachal Pradesh. For example, Mizoram. For example, Nagaland. And now Manipur has been added to this list as well. To these 4 states, you cannot enter these 4 states without the permit. And these illegal migrants can be made to settle in any other part of this territory except those tribal areas under 6th schedule, except those where inner line permit is applicable. And for them, the period of naturalization has been reduced from 11 to 5 years. Why? Citizenship Amendment Act basically says that there are 3 countries, Pakistan, Afghanistan, Bangladesh, where Islam is the state religion, where Muslims are the majority, and non-Muslims, which means the religious minorities, 6 religious minorities, they are persecuted, they are discriminated against, their rights have been violated, they are in danger, their life is in danger, their dignity is in danger, their security is in danger. And to save themselves, they have traveled to India illegally. What do we do with these people? The government said, let's enact a law. We will declare that if they have entered India on or before December 31st, 2014, they will not be deemed as illegal migrants. When they are not deemed as illegal migrants, that means they are eligible for citizenship. Through what route? Through naturalization. And for that, they have to stay in India for 5 years. You stay in India for 5 years, you are eligible for citizenship. But once you are citizens, you should be given home as well. Where do you make your home? Where do you reside? Where do you settle? You cannot settle in the tribal areas of Assam, Meghalaya, Mizoram and Tripura because those areas are exempted. You will not be made to reside or settle in those areas which come under inner line permit. For example, Mizoram, for example, Nagaland, for example, Arunachal Pradesh, for example, Manipur. Except these areas, you can reside and settle anywhere within the territory of India. That is Citizenship Amendment Act 2019. This law, Citizenship Amendment Act, also talked about something else. Grounds for cancelling OCI registration. What does that mean? OCI registration. OCI cards. You are the holder of the OCI card. Does that mean you can continue holding this card forever and ever and ever? No. If you do something, your OCI card can be cancelled. And prior to 2019, there were 5 grounds on the basis of which your OCI card could be cancelled. 5 grounds. One such ground was if you have registered for OCI card through fraud. One example of that is Atish Tasir. Atish Tasir, his father was a Pakistani. His father was the governor of Punjab, the Pakistani side of Punjab, Salman Tasir. And he was killed by his bodyguard. What was the reason for that killing? We don't have to go into that, but he was killed by his bodyguard. His wife was an Indian journalist, Tavleen Singh, who writes every Sunday in the Indian Express, one of the celebrated Indian journalists. Although they were separated, they were divorced, Tavleen Singh raised her son Atish Tasir in India. So he was an Indian, but ultimately he traveled the world, acquired the citizenship of another country. But since you had an Indian connection, he applied for OCI card. He got the OCI card. And he wrote beautiful articles praising Mr. Modi. Prior to 2014, Atish Tasir, who is a journalist, he wrote brilliant articles, beautiful articles praising Mr. Modi, why Mr. Modi is our best bet, why he should become the Prime Minister. In fact, his mother, Tavleen Singh, was also a blind supporter of Mr. Modi. But then things came to a pass where in 2019, just before 2019 elections, Atish Tasir published a cover story on the Time magazine, calling Mr. Modi India's divider-in-chief. Tavleen Singh also became the critic of Mr. Modi. And in 2019, when Mr. Modi came back to power, in 2019, afterwards, the OCI card of Mr. Atish Tasir was cancelled. Why? Because the government said Mr. Tasir had acquired OCI card, registered for OCI card through fraud. Because one condition, Pakistanis and Bangladeshis are ineligible for OCI card. So the government said that Atish Tasir has registered for OCI card through fraud by concealing that his father is a Pakistani. That is how your OCI card was cancelled. That means even if you registered for OCI card, even if you get this OCI card, it can still be cancelled on 5 grounds. Till 2019 on 5 grounds. One such ground was if you have registered for OCI card through fraud. Second, if you are showing dissatisfaction to the Constitution. You are burning the Constitution copy. You are disloyal to the Constitution. You are showing disrespect to the Constitution. Your OCI card will be cancelled. Third, if you are engaging with the enemy during war. I am a OCI card holder, but there is a war between India and China. I am doing business with China. I am engaging with China. I am traveling to China. I have business interest in China. My OCI card will be cancelled. Fourth, if it is necessary in the interest of the sovereignty of India, security of the state, or public interest. I am holding an OCI card. I can come to India without visa. Yes. So I came to India. And in India, I am now traveling to Kashmir. I am now traveling to Punjab. And in Kashmir, I am preaching secession, that Jammu and Kashmir is not an integral part of India, should come out of the Union of India. In Punjab, I am preaching for Khalistan, that we should have a separate country, Khalistan for the Sikhs. I am going to Manipur and I am instigating the Kukis against the Metis. So I am basically a threat to the sovereignty of India. I am a threat to the security of the state. My OCI card can be cancelled. Fifth ground on which my OCI card could be cancelled was if I have got this OCI card today, but within 5 years, I am arrested and I am sentenced to 2 or more years in jail. I killed somebody for which I was arrested. In United States, for example, I am a citizen of United States, but I am also holding an OCI card within 5 years, I killed somebody in United States, I was sentenced to 2 years in jail, my OCI card could be cancelled. Or if I killed somebody in India while I had an OCI card, I was sentenced to 2 years in jail or more in jail, my OCI card could be cancelled. So there were 5 specific grounds on the basis of which your OCI card could be cancelled till 2019. But OCI scheme was launched under Citizenship Act of 1955. That's what we have mentioned here. OCI card was basically launched under Citizenship Act 1955. Citizenship Amendment Act is what? It is basically amendment to the Citizenship Act 1955. And through the CAA, even overseas citizen of India registration was amended. That means now there will be a 6th ground on the basis of which your OCI card could be cancelled. And that 6th ground is if you have violated any law that is in force in the country. That means previous 5 grounds were specific. If you have got the OCI card through fraud, if you are disloyal to the constitution, if you have engaged with the enemy during war, if you are a threat to the sovereignty, integrity, security of the state, if you have been punished and sentenced to 2 years or more in jail within 5 years of getting your OCI card, now a broad condition has been applied. If you violate any law which is in force in this country, your OCI card could be cancelled. For example, I am holding an OCI card and I'm driving a vehicle without a driving license, which means I'm violating Motor Vehicles Act. For violating Motor Vehicles Act, my OCI card can be cancelled. That means the 6th ground has been added by the Citizenship Amendment Act, which is if the OCI has violated any law which is in force in this country, your OCI registration can be cancelled. This is Citizenship Amendment Act 2019. But what are the arguments in favor of this law? What are the arguments against this law? When this law was passed, there was a series of protests in different parts of this country. Particularly, series of protests at Shaheen Bagh in Delhi. Where protesters blocked an important road, calling for the repeal of this law, saying this law is bad, immoral, illogical, and as such should not be allowed to function. This law should not be passed. If it is passed, should be repealed. Particularly, there were protests by the Muslims, saying this law is anti-Muslims. Why? Because anybody can get citizenship except Muslims. That means Hindus, Christians, Sikhs, Buddhists, Jains, Parsis from these 3 countries are eligible for citizenship except Muslims. But Muslims may also be discriminated in these 3 countries. And ultimately, protests happened in different parts of this country. But when we look at the arguments in favor of this law, this is a law to confer citizenship. This is not a law to deprive Indians of citizenship. What does that mean? What does that mean? That means Indian Muslims should not protest because Indian Muslims are unaffected. Does this law say that 6 religious minorities from 3 Islamic countries will be given citizenship in India in place of Indian Muslims? No. Does that mean there are 1,000 vacancies for Indian citizenship and these 6 religious minorities will get this 1,000 citizenship and Indian Muslims will be deprived of their citizenship? No. This is a law to confer citizenship on others. This is not a law to deprive Indians of their citizenship. So how are Indian Muslims affected by this? They are unaffected because their citizenship cannot be deprived. Their citizenship cannot be taken away. Their citizenship cannot be snatched from them and given to these 6 religious minorities. So why are they protesting? This is a law to confer citizenship, not deprive citizenship. There are others who say Article 14 has been violated. And Article 14 talks about right to equality. How can you discriminate when Constitution talks about equality? How can you say except Muslims and only Hindus, Christians, Sikhs, Buddhists, Jains, Parsis? This violates the principle of equality, as such violates Article 14. That is why this law is unconstitutional. We will discuss Article 14 tomorrow, but very briefly here. Article 14 talks about equality before law. It also talks about equal protection of the laws. Equal protection of the laws means like should be treated alike. Alike in the sense, you don't like my class. You enter through this camera, use a knife and kill me, stab me, and I'm dead. Sure, matter will go to the police. Ultimately, investigation will take place and matter will ultimately go to the judiciary. Judiciary will have to decide whether you are guilty or not. And on one side are you are the accused of killing me. On the other side is my father, my family members who say punishment should be given to you. Compensation should be given to them. Can you claim equality? Equality in the sense, my lord, how can you discriminate between the two? You are saying death sentence will be given to one person and compensation should be given to another person. How can you discriminate? You have to treat us equally. How can a murderer and the victim be treated equally? That would not be equality. That would not be justice. That is why Article 14 talks about equal protection of the laws, which basically means intelligible differentia. Differentia in the sense, we have to differentiate between the two set of people. All the murderers should be treated equally. It's not that if you are a Dalit murderer, we will give you death sentence. If you are a Brahmin murderer, we will set you free. That is something which cannot happen. All murderers will be treated equally. That means all those who are in similar circumstance will be treated equally. All the victims will be treated equally. It's not that if you are a Dalit victim, we will give you 1 rupee compensation. But if you are a Brahmin victim, we will give you 1 crore compensation. That cannot happen. That means intelligently, through some sound logic, we have to differentiate between two set of people. That is allowed under Article 14. And Article 14 is not violated by Citizenship Amendment Act. Why? Because we are differentiating two set of people. Hindus, Christians, Buddhists, Jains, Parsis and Sikhs, they are victims. Victims cannot be equated with the oppressor, who are the Muslims. Not my words. This is what the law says. This is what the requirement of the law is. So don't lynch me for that. According to the government, in these 3 Islamic countries, Muslims are the oppressors. Victims are these 6 religious minorities. So if we include Muslims as well, that would be violation of Article 14. Because we have to differentiate two set of people. Victims and the oppressors cannot be equated together. So Article 14 is not violated. If we would have said only Hindus will get citizenship under Citizenship Amendment Act and not Buddhists, Jains, Parsis, Sikhs, Christians, then it would be violative of Article 14. Why? Because why are you only picking one victim, which is Hindu? Why not other victims? There are other victims as well in these 3 Islamic countries. If you would have done that, you are violating Article 14. But you are not violating Article 14 because you have clubbed all the victims together. You have excluded the oppressor. You are treating victims separately. Article 14 is not violated. In fact, Article 14 is upheld. So Citizenship Amendment Act basically is an amendment to the Citizenship Act of 1955. According to this amendment, if you are from 6 religious minorities, belonging to 3 Islamic countries, you have come to India on or before December 31, 2014, you are eligible for citizenship through naturalization. Now, you may have 2 questions on your mind. Sir, why December 31, 2014? That would be the question on your mind. And why this period of naturalization has been reduced to 5 years? Clear? Why December 21 to 31, 2014? I don't have an answer. Why? Because it is not mentioned in the law. It's not mentioned why this date specifically has been chosen. December 31, 2014. We don't know. There is no explanation provided. But one explanation is provided by the Assam Chief Minister, Himanta Biswa Sarma. Mr. Sarma says, before 2014, a lot of illegal migration happened in India. But what happened in 2014? Mr. Modi came to power. And with magic wand in his hand, he stopped all the illegal migration. So illegal migration happened only till 2014. After Mr. Modi came to power, there is no illegal migration. So when illegal migration happened only till 2014, why should we talk about illegal migration after that? Since illegal migration happened only till 2014, we are talking about till 2014. Whoever has entered, if you come from Pakistan, Afghanistan, Bangladesh, belonging to these 6 religious minorities, you are not illegal migrants, which means you are deemed as the legal migrant, which means you are eligible for citizenship through naturalization. But why this period, which was meant to be 11 years for naturalization, was reduced to 5 years? When was this law passed? Citizenship Amendment Act 2019. When, according to Mr. Sarma, illegal migration stopped? 2014. Time period between 2014 to 2019 is 5 years. That is why the period of naturalization reduced from 11 to 5 years. Is this a good law, a bad law, or an ugly law? Arguments in favor. This is a law to confer citizenship. This is not a law to deprive Indians of their citizenship. So why are Indian Muslims protesting? There are people who are crying, right to equality has been violated because you cannot discriminate on the grounds of religion. Article 14 is violated. Article 14 is not violated because Article 14 talks about intelligible differentia, which distinguishes persons or things that are grouped together from others that are left out of the group. Those who are grouped together are religious minorities. Those who are left out is a majority religion. And we have the objective, a rational objective. What is the objective? To confer them citizenship and not confer them citizenship. That is Article 14. Article 14, which talks about equal protection of the law, is not violated by Citizenship Amendment Act. And Indian Muslims are in no way affected by this amendment. They are and will continue to enjoy all the benefits as legitimate Indian citizens. This law deals with refugees who are foreign citizens, who are citizens of Pakistan, Afghanistan, Bangladesh. It is for them that we are creating this law. Indian citizens are not affected by this law. That's another argument. Another argument is, some people said, critics said, why are you only talking about Pakistan, Afghanistan, Bangladesh? What about Sri Lankan Tamils? Why are they not covered under this law? The government says there is a difference between persecuted religious minorities and those who are persecuted because of their ethnicity. Sri Lankan Tamils, they are being persecuted not because of their religion, but because of their ethnicity, because they are Tamil, because they speak Tamil language. That's why they are persecuted. That's why they are being targeted. Hindus, Christians, Buddhists, Jains, Parsis, Sikhs in Pakistan, Afghanistan, and Bangladesh, they are targeted, they are persecuted, they are under assault because of their religion. And it is basically a policy decision. Policy decision in the sense, we have this live online classroom program where we complete the entire syllabus of general studies in more than 840 plus hours. Fine. Can you tomorrow tell me and ask me and question me, why do you teach polity at the start, followed by other subjects? That's our policy. Are we not completing the syllabus? Yes, we are. Then it is our policy to start with polity, for example. Why are your courses expensive? Whereas if you look at other coaching institutes, their courses are very cheap. That's our policy. If you like their content, please go and pay them and consume their content. The reason why you are here, you're consuming this content is maybe because you assume or you think that this content is worthy of the money that we pay. That's our policy. We will have this as so-called expensive course. That's our policy. And if the government has decided that first we will focus on those who have been targeted because of their religion, later on we will look at those who have been targeted because of their ethnicity. That's the policy of the government. You can't question the policy of the government. That's another argument in favor. There are also others who said Article 15, Article 21 is getting violated. Article 15, which talks about non-discrimination on the grounds of religion. The state shall not discriminate only on the grounds of religion. Since the state is discriminating only on the grounds of religion, because only on the grounds of religion, some people will be given citizenship. Only on the grounds of religion, one community will not be eligible for citizenship. So making religion as a ground for discrimination is unconstitutional and violates Article 15. Right. Except one thing, that Article 15 does not apply to aliens. If Indian citizens would have been discriminated on the grounds of religion, then it is unconstitutional. But we are talking about not Indian citizens, foreigners from Pakistan, Afghanistan, Bangladesh. If you belong to 6 religious minorities, we will give you citizenship. So this law is talking about dealing with foreigners. And foreigners, they don't enjoy all these fundamental rights. Specifically, they don't enjoy Article 15. So even if Article 15 is violated, that is not a valid ground against this law, because this law talks about foreigners. And Article 15 as a fundamental right does not apply to foreigners. They say Article 21 is violated, right to life. Article 21, which says the state shall not deprive an individual of his right to life and personal liberty. Article 21 is getting violated. A beautiful argument to this was given by Mr. Harish Salve. Mr. Harish Salve says, Article 21, yes, it is applicable to foreigners as well as Indians. But Article 21 comes into the picture for all those who are present on the soil of India, On the soil of India, whether you are a foreigner or you are an Indian, doesn't matter. You have the right to life, you have the right to personal liberty. But here, what are we talking about? Under Citizenship Amendment Act, we are talking about those who are coming to India from Pakistan, Afghanistan, Bangladesh, belonging to 6 religious minorities. So those people have to come to India, and here in India, we will give them citizenship. Which means Article 21 is not violated either. And this law is good because it protects tribal interests as well. Because the law specifically says that this law will not enter into force in the tribal areas, those areas under the inner line permit. So we are protecting the tribal interests as well. That's another good thing about this law. And there were others, for example, Mr. Kapil Sibal, a member of Rajya Sabha, although also a prominent constitutional expert, a lawyer, a senior advocate of the Supreme Court, he said this law should not have been even discussed in the parliament. He went to this extreme, saying it is immoral for the parliament to even discuss such a law. This law should not have been even discussed in the parliament. But perhaps the answer to Mr. Kapil Sibal is given by Dr. Ambedkar himself. Dr. Ambedkar, the architect of the Constitution, what did he say? He said the job of this article, the job of this Constitution is not to lay down a permanent law for citizenship. What did I tell you right at the start? Citizenship as a chapter is not normally mentioned in the Constitution. But since India is unique, because the country was partitioned, unfortunately on the religious grounds, we had to be absolutely sure who are the citizens of India right now when the Constitution was enacted. After that, Parliament has been given power under Article 11 that you can pass a law, and through this law you can regulate all matters related to citizenship. Permanent law for citizenship, that's the matter to be left to the legislature. That is the solemn power of Parliament under Article 11 to lay down the law related to citizenship. How can Mr. Kapil Sibal, you say that Parliament should not even have discussed this law? That's the job of the Parliament, to regulate all matters related to citizenship. One such matter is Citizenship Amendment Act. These are the arguments in favor of this law. Any questions as of now? Okay. What about those such as Sri Lankan Tamils and Tibetans? CAA specifically focuses on the persecuted religious minorities. It doesn't mean other classes of refugees would be ignored. Tibetans continue to stay in India. The Tibetans are being persecuted by China not because of their religion but because of their ethnicity. Similarly, Sri Lankan Tamils are being discriminated not because of their religion but because of their ethnicity. Even then, Sri Lankan Tamils are residing in India. Even then, Tibetan Buddhists are residing in India. But they will be dealt separately, not by CAA. Problem solved. But what are the arguments against citizenship, against the Citizenship Amendment Act? The most important argument against this is making religion as a qualification from granting citizenship. There is a war going on between Israel and Hamas. In Israel, they have a law known as the law of return. And what is that law? If you are a Jew if you practice Judaism of Prophet Moses, no matter where you are, whether in India, Pakistan, Sri Lanka, Bangladesh, US, Canada, Japan, Germany, North Pole, South Pole, any pole, if you return to Israel, you will get citizenship of Israel. That means in Israel, religion is a qualification to become citizen. And in any country where religion becomes a qualification for granting citizenship, that country cannot be secular. And the Supreme Court has said secularism is part of the basic structure of the Constitution. So Citizenship Amendment Act 2019 violates secularism, which is part of the basic structure of the Constitution, and as such is unconstitutional. Why? Because when you make religion as a qualification, you're basically going against the spirit of secularism. So instead, what could have been mentioned? Even if you would not have mentioned Hindus, Christians, Buddhists, Jains, Parsis, and Sikhs, only if you would have mentioned all those who have been persecuted because of their religion, if they have come to India, they will get citizenship through naturalization. Problem would have been solved. Without mentioning any religion, without excluding any religion, without including any religion, you still would have been able to realize your objective. Because who are religiously persecuted in Pakistan, Afghanistan, Bangladesh? 100% non-Muslims. So when non-Muslims are persecuted because of their religion in these three countries, if these non-Muslims come to India, we will give them citizenship. Even without mentioning religious names, even without mentioning religions, objective would still have been achieved. But since you're making religion as a qualification, you're going against the spirit of secularism, which is part of the basic structure of Indian Constitution. Sir, why did the government not use this language then? Without mentioning religions, they would have only mentioned religious persecution. This is something that Dr. Subhash Kashyap says. Subhash Kashyap, whose book you may be reading or may have read. Dr. Subhash Kashyap, a constitutional expert, he said without mentioning religions, the same objective would have been achieved. But why did the government not use this logic? Maybe they deliberately wanted to add religions for whatever reason. That's argument number one. Argument number two, Article 14. Way back in 1952, there was a judgment of the court Anwar Ali Sarkar. In this judgment, Supreme Court said, intelligible differentia, which basically means when you are differentiating two set of people, basis some intelligent points, for example, some rational logic, for example. Even this yardstick that you use to include some and exclude some, even this yardstick has to be reasonable. You include some, you exclude some. That is how you can classify two set of people. But on what grounds are you including people? On what grounds are you excluding people? This ground has to be rational itself. And this ground cannot be religion. Cannot be religion. Because according to the recent judgment of the court, in section 377 judgment, which is also known as Navte Johar judgment, What was this Navtej Johar judgment? Section 377 of Indian Penal Code. It talks about unnatural offenses. What are these unnatural offenses? If you are having a carnal intercourse which is against the order of nature, it is a crime, it is an unnatural offense, for which you may also be given life imprisonment. What is this carnal intercourse against the order of nature? Any sexual interaction which is not peno-vaginal in nature, which does not involve the two organs of male and female, such an intercourse is unnatural, is against the law of nature, and as such is a crime. And this section 377 was primarily targeted at homosexuals. For example, lesbians, gays, bisexuals, transgenders, queers. Basically, sex between man and a man, because it does not involve the two organs of male and female. It is unnatural. Sex between female and a female, because it does not involve the male organ as well, as such is unnatural. It's a carnal intercourse against the order of nature, as such is a crime. 2009, in a case known as Nas Foundation, Delhi High Court said Section 377 is unconstitutional. Why Section 377 is unconstitutional? Because it violates fundamental rights. What fundamental right does it violate? Article 15, which talks about there can be no discrimination on the grounds of religion, race, caste, sex. Sex means sexual orientation as well. Whether you are gay or straight doesn't matter. If on this ground, on the basis of your sexuality, you are being discriminated against, it is unconstitutional, violative of your fundamental rights. It violates Article 21, violates your dignity as well. Section 377 is unconstitutional. But few years later, in 2012, in Koshal judgment, Supreme Court said no, Section 377 is constitutional. Why constitutional? Supreme Court said this is a matter which should be decided by the legislature. Indian Penal Code, which started in 1860, till 2013, it has been amended multiple times. Parliament never decided to repeal Section 377. Parliament never decided to amend Section 377. So why are we doing it? How should we do it? This is a matter which should be dealt by the government. This is a matter should be dealt by the Parliament. We will not interfere. Supreme Court was told, but Supreme Court, the law is being misused. Said, how? Said, there are two men holding hand in hand. They are arrested by the police. There are people who are making love inside their home. They are being knocked and the door is opened and they're arrested for committing homosexuality. Their dignity is getting violated. The court said, see, if the law is being misused, that's the problem of the police. That is not our problem. Our problem is clear. This law is constitutional. If Parliament decides to repeal this law, we don't have an issue. But let Parliament take this call. We cannot. But then in 2017, in this famous landmark Navtej Johar judgment, Supreme Court said Section 377, insofar as it criminalizes homosexuality, it is unconstitutional. Once a judge was Justice Indu Malhotra, who was part of this bench. And what she did, she infused Article 15 into Article 14. Article 15 talks about no discrimination on the grounds of religion, race, caste, sex, place of birth. This is similar to Article 14, which talks about non-discrimination, which talks about equality. Sir, what does that mean? Article 14 only talks about equality before law, equal protection of the laws, which basically means there can be no discrimination. But it does not mention on what grounds there can be no discrimination. Article 14 is applicable to everybody, including a foreigner, including an alien. Justice Indu Malhotra said, don't worry. Article 15, which talks about no discrimination on the grounds of religion, race, caste, sex, place of birth, same set of discrimination cannot be carried out under Article 14. That means even under Article 14, there can be no discrimination on the grounds of religion. Article 14 is applicable to foreigners, which means even if you discriminate foreigners on the basis of a core intrinsic trait of that individual, that core intrinsic trait is a religion. So even religion cannot be the basis for discrimination. You understood what are the arguments in favor of this law? Now we are trying to understand arguments against this law. What are the arguments against this law? First, if you make religion as a qualification for getting citizenship, you are basically similar to Israel, which is a theocratic state, which means you are not a secular state. When you are not a secular state, but secularism is part of the basic structure of Indian constitution, CAA is unconstitutional. Even Article 14 is violated. Because what Article 14 talks about? Equality before law, equal protection of the laws. That means you have to provide equality. You cannot discriminate. But what are the grounds on the basis of which you cannot discriminate? Justice Indu Malhotra says, if there is a core intrinsic trait of an individual, a core part of an individual, on that core part you cannot discriminate. And one such core part, she says, is religion. So religion cannot be the basis for discrimination. And we are fusing Article 15 with Article 14. If Article 15 says there can be no discrimination on the grounds of religion, which means under Article 14 also you cannot discriminate on the grounds of religion. Which means since Article 14 is applicable to foreigners as well, CAA is unconstitutional because it discriminates only on the grounds of religion. There are other arguments. When this matter is heard by the court, because right now the courts are hearing this matter. They will hear this matter because they are right now hearing something specific to citizenship, which is Section 6A, which we will discuss today. But when the courts will formally begin hearing arguments on this CAA, they will ask the government attorney general, the government lawyer, how do you justify this law? Because you have to justify this law. The government may say, we have enacted this law because Pakistan and Bangladesh were part of British India. Because you have to justify, why are you including only these three countries, Pakistan, Afghanistan, Bangladesh? Why are you excluding other countries? Why not Myanmar? Why not Nepal? Why not Sri Lanka? Why not Bhutan? Why not other countries in our neighborhood? Why only Pakistan, Afghanistan, Bangladesh? And why only these 6 religious minorities? You will have to explain. So that you can convince the court that our classification, our differentiation is logical. It's not illogical. The government lawyer may say, sir, we are including Pakistan and Bangladesh because it was part of British India. Myanmar was not part of British India. Sri Lanka was not part of British India. And that is why Pakistan and Bangladesh have been included. The courts will ask, what about Afghanistan? It was not part of British India. It may have been part of your concept of Akhand Bharat, but it is not part of the British India. So by including Afghanistan, you have not logically created this classification. The government may say, no, Pakistan, Afghanistan, and Bangladesh we are including because in these three countries, there is a state religion. That's why we have included these three countries. The court will say, do you know about Sri Lanka? Yes, their Buddhism is a state religion. Why did you not include Buddhism, Sri Lanka, in your Citizenship Act? In Myanmar, there is one form of Buddhism which is a state religion. Why did you not include Myanmar? If you are including only Islamic countries, then it is not a reasonable classification. Because then you should have also included those countries where another religion is a state religion. Or the government will say, no, we are talking about including these three countries because look at the degrees of harm. Massive, horrific, horrible atrocities are being committed in these three countries. That is why we include only these three countries. The court will ask, what about Myanmar? In Myanmar, there is a group known as Rohingyas. Rohingyas can be Hindus as well, but predominantly they're Muslims. They're being persecuted in Myanmar. That is why they are leaving Myanmar, coming to India, coming to Bangladesh. And according to United Nations, worst human rights violations have been committed against Rohingyas. So if you are including 6 religious minorities in these 3 countries, based on the degrees of harm, you are saying that citizens or minorities in these 3 countries, they are more persecuted as against other countries. You are wrong, because Rohingyas in Myanmar, according to United Nations, are the worst sufferers of human rights violations. And why are you not including atheists? Atheists in Bangladesh and Pakistan are also attacked. Why not include atheists? And if you're saying all religious minorities have been clubbed together and only one religious majority has been excluded, what about Jews? Why are they excluded? What logic have you employed to exclude Jews and atheists from Citizenship Amendment Act ambit? On all these grounds, you are making an unconstitutional law. The law is unconstitutional. Something else. December 31, 2014. Why? Why was this date chosen? Arbitrary. Without any logic. Which goes against Article 14. Laws cannot be arbitrary. Arbitrary in the sense, the same example I gave you in the previous class. If I were to say all the students who join this class between 6 to 7 a.m., they cannot ask me questions. Those who join my class between 7 to 8:30, they can ask me 10 questions. Those who join the class between 8:30 to 9:30, that's when the class ends, they cannot ask me any questions. This is illogical. This is not rational. This is arbitrary, based on my own whims and the fancies. I get up early in the morning and tomorrow I'll change the rule and say all those who join between 6 to 9:15, they cannot ask me any question. And those who join between 9:15 to 9:30, they can ask me hundreds of questions. This is arbitrary, illogical. Instead, if I can say all those who are from engineering backgrounds, they can ask me 10 questions. All those from law background, they can ask me only one question. At least this is a reasonable thing to do. But choosing this December 31, 2014 as the cutoff date, this is arbitrary and as such violates Article 14. Not just this. According to Faizan Mustafa, who was the Vice Chancellor of Constitutional Expert, ex-Vice Chancellor of the Nalsar University of Law, Hyderabad. He says Citizenship Amendment Act is more like the Israeli law of return, where if you are a Jew in any part of the world, if you return to Israel, we will give you citizenship. Similarly, if you are a non-Muslim, anywhere in our neighborhood, you can come to India, we will give you citizenship. So this is like making religion as the basis of your religion as the basis of your citizenship. Something else. Article 11 and Citizenship Amendment Act. Maybe Kapil Sibal was right. Can Parliament, through an ordinary law, because Citizenship Amendment Act is an ordinary law passed by simple majority, can Parliament, through its ordinary law, disturb the basic structure of the Constitution? No. So if Parliament is using Article 11 to violate secularism, which is part of the basic structure of the Constitution, through passage of this constitutional amendment, this Citizenship Amendment Act, this is violation. That is why Kapil Sibal did not say Parliament should not have even discussed this law. Kapil Sibal meant Parliament should not have discussed this law, which according to him violates basic structure of the Constitution, which basically means even using Article 11, you cannot disturb the fundamental values which are part of the Constitution. And then there is something else. Law and the lie. And what is this law and the lie? For that, we need to look at NRC. Seema, what is your question? Please tell me. Tell me whatever questions you have right now, let me know. What is NPR? My dear, we will reach there. Till now, whatever we have discussed, if you have questions around those topics, let me know. Bangladesh. If you belong to 6 religious minorities, you are not illegal migrants, we will give you citizenship. Instead, you could have mentioned all those who are persecuted because of their religion. And if they come from Pakistan, Afghanistan, Bangladesh, we will give them citizenship. Without mentioning which are these religions which have been persecuted. Without mentioning Hindus, Christians, Sikhs, Buddhists, Jains, Parsis. Because without even mentioning them, it would have meant the same. Because who are being religiously persecuted? Non-Muslims. But by excluding specific religious terms, you would have made it a religion-neutral law. Is governor not a symbol of federal structure? My dear, ask questions related to citizenship, not governor. We'll discuss governor later. Please repeat Indu Malhotra's argument. We discussed in arguments in favor of CAA that Article 14 is not violated. Clear? We discussed that Article 15 is also not violated. Why? Because Article 15 is applicable only to citizens, not to foreigners. Under Article 15, what are the grounds on the basis of which there can be no discrimination? One such ground is religion. Indu Malhotra says, apply the same logic in Article 14. That means even in Article 14, you cannot discriminate on the grounds of religion. Article 14 is applicable to foreigners as well as citizens. Article 14 says that according to Indu Malhotra, even religion cannot be the basis for discrimination. And since you are making religion as the basis for discrimination, Article 14 is violated. If any foreigner boy married to an Indian, can he become the citizen of India? Yes, provided you stay in India for 7 years. CAA passed by which amendment act? CAA is not a constitutional amendment. CAA is amendment to Indian Citizenship Act of 1955. Details of the citizens of India. So basically it's a database, it's a list of all the Indians, only the Indians, National Register of Citizens. This was last updated in 1951. So in 1951, NRC was carried out, wherein all the details of the Indians were mentioned. Only the citizens of India were mentioned. So all these set of people, they are the citizens of India. Something happened in Assam. In Assam, there was a migration of people. Those who are working in the tea plantation gardens of Assam. Sometimes people from other parts of the country, such as Jharkhand, such as West Bengal, such as Odisha, they were brought to work in these tea plantation gardens in Assam. But those who were the original inhabitants of Assam, the original residents of Assam, the Assamese people, they thought that if more and more outsiders come to Assam, they will change the culture of Assam. They will change the language of Assam. So after a point, Assamese would not be spoken in Assam. They will change even the culture of Assam. Basically, the demography of Assam will change. If right now, for example, 100% of Assam is, the residents of Assam are 100% Assamese, tomorrow we will lose our majority. We can become 50% in Assam. The remaining 50 will be the migrants coming from other parts of the country. Then we realized that in Assam, people are not only coming from other parts of the country, they're coming from other countries as well, from Myanmar, from Bangladesh as well. The Assamese people in 1979, they said enough is enough. 1979, they launched a movement which continued till 1985, known as the Assam Agitation. This was led by the students. One such student organization was ASU, All Assam Students Union. What was their principal demand? Their principal demand was NRC should be carried out in Assam, so that we can know who are the original inhabitants of Assam. All those who have come to Assam from outside, they should be arrested and deported. So if you have come from Bengal, arrest and deport to Bengal. If you have come from Odisha, if you have come from Jharkhand, deport. If you have come from Bangladesh, deport. This was the agitation. For 6 years, this agitation continued in Assam. And ultimately, there was a compromise. Something known as the Assam Accord of 1985, which was signed by the government of India, the government of Assam, and the representatives of this agitation, All Assam Students Union. Rajiv Gandhi was the Prime Minister, and the Assam Accord was signed. According to this Assam Accord, NRC will be carried out in Assam. All those who have entered Assam on or before January 1, 1966, they are the citizens of India. We will not arrest them, we will not deport them. They are the citizens of India, they will remain in Assam. All those who have entered Assam between 1st Jan 1966 till the midnight of 25th March 1971, they will continue as the citizens of India, but no political rights for 10 years. After 10 years, they have to register to become the citizens of India. And all those who have entered Assam on or after 25th March 1971, you should be arrested, you should be deported. For that, we need NRC. What is NRC? National Register of Citizens. What does it contain? The list of the citizens of India. When was it updated? 1951. What happened in Assam? There was an agitation. Why? Because Assamese felt that there is massive migration of people into Assam from other parts of the country, from foreign countries as well, particularly Bangladesh. And through this migration, our culture, our demography is under threat. An agitation was launched for 6 years between 1979 to 1985 by the students and activists of Assam, particularly All Assam Students Union, ASU. Ultimately, a compromise was reached. Assam Accord was signed in 1985. And this Assam Accord said, number one, we will implement NRC in Assam, only in Assam, so that we can see who are the citizens of India, those who can reside in Assam. We have to look for documents. If you have entered Assam before 1st January 1966, you are safe, you are citizen of India, citizen of Assam. You can reside in Assam. But if you have entered Assam between 1st January 1966 till 25th March 1971, you will have no political rights for 10 years. That means for 10 years, you cannot contest elections. 10 years, you cannot vote in Assam elections. After that, once that 10-year period is over, you can register to become the citizen of India, and we will support you. But all those who have entered on or after 25th March 1971, identify them, deport them. Why this date is important? Why specifically this date? This was when Operation Searchlight was launched by Pakistan Army. West Pakistan, East Pakistan. East Pakistan, the Bengali majority Pakistan. They were subjugated by the West Pakistan. They were crying for independence. They were crying for separate country. Pakistani army would arrest their leaders, kill them, rape their women, so on and so forth. But when the movement was launched by the Bengali people in East Pakistan that we need a separate country, Pakistani army launched a massive operation known as Operation Searchlight. And they wanted to search, they wanted to identify who are those who are supporting India, who are those who are supporting independence. We will identify them, kill them, torture them, rape them, maim them. Fearing Pakistani army, there was a massive migration of people from East Pakistan, and they wanted to save their lives. And where will they go? They entered India. Where will they go in India? They entered Assam as well. So there was a massive migration of people, particularly after this date. And Assamese people said, enough is enough. Such kind of migrants we will not accept because you're changing our demography. And Assam Accord said, all those who have entered after that Operation Searchlight, we will arrest them, we will deport them to Bangladesh. But even after 1985, this Assam Accord was not implemented. Matter went to the court. Sarbananda Sonowal, who later on became the Chief Minister of Assam, approached the Supreme Court saying, my lord, Assam Accord has not been implemented. NRC has not been carried out in Assam. Justice Rohinton Fali Nariman, Justice Ranjan Gogoi, they were the judges and they said implement NRC in Assam. That is how Assam, only in Assam, NRC was carried out. And when NRC was carried out, 1.9 million people in Assam could not prove that they are the citizens of India. They could not prove that they are the citizens of India. When NRC was carried out in Assam. According to some critics, they say that this Citizenship Amendment Act, it was the principal objective of this law was to somehow look at out of these 1.9 million people who are the non-Muslims, so that these non-Muslims can be saved and they can become citizens. Why? Because now the government, or according to some experts, they say the government can tell these people to lie. These 1.9 million people who previously claimed that we are the citizens of India, they submitted documents. But even after submitting documents, they could not prove that they are the citizens of India, which basically means that they are no longer citizens of India. Their name is not mentioned in the NRC. Now, out of these 1.9 million people, non-Muslims would be told, you just have to lie. Lie what? You just say we came from Pakistan, Afghanistan, Bangladesh. On or before December 31, 2014, we will give you citizenship under the Citizenship Amendment Act. And that's precisely why Assam is protesting. Assam was protesting. Because according to Assam Accord, all those who have entered Assam after 25th March 1971, they should be identified, arrested and deported. So the cutoff date for Assam was 1971. But now the cutoff date becomes something else. Cutoff date becomes 31st December 2014. So basically all those who have entered Assam between 1971 till 2014, they will get the citizenship of India. They will reside in Assam. The protesters in Assam, they were saying, doesn't matter to us whether the illegal migrants are Muslims or non-Muslims. We are concerned with illegal migration because it is affecting our culture. Previously, you said till 1971, whoever entered, okay, after that we will identify and deport them. Now you are saying till December 2014, which means every illegal migrant in Assam becomes the resident of Assam and our demography will change. That is why even in Assam, there were protests because not all areas under Assam are under the 6th schedule of the constitution. There are only 3 districts. The remaining districts, these migrants can be made to settle. The CAA has not been implemented yet. CAA not implemented yet. Why? Rules not made by government. What does that mean? CAA says if you have come from Pakistan, Afghanistan, Bangladesh, if you belong to 6 religious minorities, and you have entered India on or before December 31, 2014, you are eligible for citizenship. That's what the law says. And law is always a broad law. Then to implement this law, we have rules. The Ministry of Home Affairs had to make rules. What are these rules? How do you prove that you are from Pakistan, Afghanistan, Bangladesh? How do you prove that you have come to India on or before December 31, 2014? How do you prove that you are from Hindu, Sikh, Buddhist, Jain, Parsi community? How do you prove it? For that, there are some documents that you need to furnish. What are those documents? For that, we need rules issued by the government, and the government is not implementing rules. Why? Because the government previously said, after 2019 law, when it was passed, COVID-19 struck the country. That is why we could not pass this law. Then the BJP went to West Bengal elections with a promise that if you vote for us in our first cabinet meeting, we will implement Citizenship Amendment Act. Why? because majority of these 1.9 million people who could not prove that they are the residents of Assam, they are from Bengal. So to save them, we will implement Citizenship Amendment Act. But BJP didn't come to power in West Bengal, which basically means this law could not be implemented. But whatever the case is, CAA 2019 has not been implemented yet because the rules to implement this law have not yet been made by the government. But what and how CAA impacted our foreign policy, how CAA is linked with NRC, how CAA is linked with NRC and the NPR, and how census and why caste census is a big issue, that we will discuss tomorrow. Clear? Yes. Everyone is in favor of CAA 2019 because CAA 2019 talks about people coming from abroad, right? Coming from Pakistan, Afghanistan, Bangladesh. And in India, they will get citizenship. Article 21 is applicable to foreigners as well as Indians. But those who are already present in India, that is what Harish Salve said, but these are the people who are coming from abroad. That is why Article 21 is not applicable to those coming from abroad. But I personally don't agree with his statement. Why? Because these are the people who are not coming now. They're already here. Those who have come on or before December 31, 2014. So all these people whom you want to provide citizenship, they're already present. So when they're already present, you cannot violate their right to life and liberty. Tomorrow, yes, there will be a class on fundamental rights. Consulting constitutional experts, they do. The reason for Shaheen Bagh protest we'll discuss tomorrow. How, when we discussed the arguments against, we discussed that this law is completely illogical. So we have to understand both pictures. But that doesn't mean my argument is in favor, or I am in favor of this law, or I'm against this law. I'm neither in favor nor against. My only purpose is to tell you arguments in favor as well as against. Because if tomorrow you are asked critically analyze Citizenship Amendment Act 2019, you have to mention arguments in favor as well as against. This is before the court. We'll discuss tomorrow. Okay, let's meet tomorrow, 6 o'clock in the morning. Till then, have a great time. Bye-bye.